Remembering that that's not all of the addenda, but those are the most commonly used ones. Again, if you get a test question on any of these addenda, I would say they'd give you a scenario and then say which addenda should you use, and then give you an option there of four. So the only ones you guys need to worry about are the ones that we went over in class. 305 over to the backup contract addendum on 307. And again, just a basic understanding. What questions do we have? Anything from last week? Anything from Thursday with the addenda and the offer purchasing contract? All right. Well, I got a question for you guys then. So if you guys will go ahead and set your chats to private. And in a private chat, remind me which offers we present to sellers. Which offers do we present to sellers? Good morning. You're just joining us. You're telling me in a private chat which offers we present to sellers. Can you hear now? Let's see where she at. Can you hear us now? Perfect. Everybody in? Doesn't look like it. Which offers? Hint, it's a simple one-word answer. Good morning. So which offers do we present? All of them. You hear my absolute word? Is there an exception to all? Present all offers except for the lowball one that's going to upset your seller, or except for the lowball one that's going to be less commission for you. Is that what I'm saying? Except for the 2-year lease to own that you don't want to deal with. No, that's not what am I saying, am I? What offers do we present to sellers? Let me see everybody's mouth move. Which offers? All offers, every single one. So with that being said, we are on page 307, talking specifically about submitting offers to sellers. And so the good news is we've discussed some of this. Part of the commission rule says that we have a duty to present all offers. I said sellers, but you know what? If your seller makes an offer to the buyer, if your seller makes a counter offer, that is also an offer that has to be presented. So forget what I said specific to about sellers. I guess the question I should have asked is which offers do we present? Period. Sellers, buyers, to anybody. Everybody with me? Doesn't matter who you're presenting them to, we still have a duty to present them. So we have a duty to present all offers immediately, but in no event later than 3 days. So when do we present all offers? Immediately. You see the 3 days is in parentheses? That's your afterthought. When do we present them? Immediately, but in no event later than 3 days. If we're presenting more than 2 or 3 days, there's got to be a reason. I'm thinking your sellers are out of town or they're dealing with a family thing, right? Like something's come up, because I don't know. It's 2024. How long does it take us to pick up the phone and call somebody with an offer, or send an email and say, hey, we got an offer? Is it taking you 3 days? It really shouldn't. Guys, we talked about communication last week and the broker communicating acceptance of an offer. It's so important that agents communicate promptly with each other. I don't know about you guys, but let's say I'm a listing agent and I get an offer in this morning, but I'm busy because I teach till 1 and I got a meeting at 1, and then I'm going to have to find some lunch, and then I got to do a couple other things. So it may be this evening before I get a chance to call my seller. And in the meantime, I don't know, another offer comes in. Or if I'm the buyer's agent and I'm not communicating until this evening, and then another offer comes in. I guess what I'm saying is I'd have a hard time putting my head down tonight, going to sleep, knowing that I was the reason, my lack of communication was the reason why somebody missed out on an opportunity to buy or sell a property. Does that make sense? So communicate promptly, communicate efficiently, communicate. And that does include submitting our offers to our sellers, all offers immediately, but in no event later than 3 days. And remember, as a sales agent, brokers are a special agent. Sales agent is special agent brokers. And as a special agent, what power do I have to accept or bind or commit my buyers and sellers? What power do I have? You can all show me. Yeah, zero. So we cannot accept or reject an offer on a seller's behalf, even if it's that low ball offer that you know is just going to make them mad. Have this conversation at the listing before we go on the market. I had a seller once that looked at me and said, I can't afford to sell for anything less than, I don't know, make a number up, 150. Said, I can't afford. If it's anything less than 150, I'm going to have to rent. I can't afford to do it if it's less than 150. I said, awesome. So we listed it like 180 or something like that. We got a lowball offer. Lowball offers are a thing. Sometimes buyers are just testing the waters, right? We got a lowball offer for under 150. Is my seller going to accept that? No, he told me he couldn't do it. What do you think I did? Sorry, we reject it. No, I still had to call my seller. And I told my seller, I'm like, I have a duty to present all offers. And if anything comes in under 150, I still need to present it to you. I can't be the one to reject it. And he said, that's fair. So that offer came in. I called him. I said, hey, how you doing? He said, I'm good. I said, we got an offer for whatever it was. And he said, I can't accept that. I said, awesome. Have a nice day. And that was about the extent of our conversation. But who's the one that made that decision to not accept that offer? Wasn't me, was it? It was him. What if something happened to his financial situation last night and he had to sell no matter what, and he just hadn't a chance to call me yet, and then he found out that I rejected that offer on his behalf? Do I have an upset seller? You better believe I do. So keep it simple, you guys. Don't pick and choose. Just present all offers. Let them be the one to decide. By the way, with that scenario I just gave you guys, even though I called him and said we have an offer for X amount, I still have a duty to present. So I still sent him the offer. I still emailed it to him for his records. Everybody hear me? There's a difference in calling and saying I got an offer versus actually providing it to them, handing it to them. And we still have a duty to do that no matter how we communicate. Questions on this? Another thing with dealing with offers you very well may encounter if you were real estate 2 years ago, this was your MO, multiple offers. You may be in a situation where you are the listing agent and you have more than one offer. So we need to learn how to handle multiple offers. First off, understand multiple offers are not a material fact, which means I don't have to disclose if we have multiple offers or not. Whether or not we disclose the presence of multiple offers or another offer is up to the seller. So we need to have the conversation with the seller. Do you want to let other buyers know that we have other offers in our hand? Again, you guys, I'm sending you an offer this afternoon is totally different than here is our offer. In your hand and on its way are two different things. So we're talking about ones that I have in my hand. So we talk to the seller and we say, do you want to tell other buyers? Do you want to tell other agents that we have multiple offers? Here's the deal. Buyers. Some buyers, when they find out we're in a multiple offer situation, will up their game. They'll bring their A game to the table. They'll have a non-negotiable in their mind, purchase price, due diligence, earnest money. They're putting all their cards on the table and saying, this is what I got. Other buyers, when they find out there's multiple offers on the table, will run away. They don't want to deal with the competition. So the seller needs to decide how we're going to handle that. The other thing you guys need to be aware, there's no license law or commission rule that prevents another agent from calling and asking, do you have other offers? How we respond is per the instructions of our sellers. Does that make sense? So the agents are going to call and ask, and if your seller doesn't want to disclose, my seller doesn't want to disclose that an honest answer? I mean, that's just about as honest as we get, right? I'm not telling you yes, I'm not telling you no. I'm just telling you my seller doesn't wish to disclose. With multiple offers, they need to be delivered or presented at the same time in no particular order. I can't favor one offer over another. So the highest price offer, the higher the sales price, the more I stand to make, right? So I can't say, well, here's the highest priced offer. Let's just look at this one first, and then we'll address the other ones later. What if the offer, or there's an offer from another agent in my firm representing the buyer? We're in dual agency. Doesn't the firm stand to make out when we're on both list and sell side? So would I not want to hang on to that one? Just talk about that one and then talk about all the other agents' offers, the co-brokered offers? Can't do it. What if you're a single agent, dual agent, and you stand to make both sides commission on the same property? Can you withhold the other offers to just present that one? No, we have to deliver them all in no particular order. I cannot favor one offer over the other. I think as we're learning, there's a lot more to the offer to purchase and contract than how much and when. That seems to be what sellers care about. How much are they offering and when do they want to close? Well, that's two important pieces. I'll give them that, but that's not all. Other things to take into consideration: due diligence, earnest money. Are the dates favorable to your sellers? Is the buyer asking for seller paid closing costs? Are they asking for a home warranty? All those blanks that we fill in with money signs next to them, those should all be something that the seller needs to consider. And they need to have all of the information at once in order to consider. I'll share with you, I think one trick that came out of this crazy multiple offer world that we're easing our way out of. I know a lot of agents, you start dealing with double-digit offers and things start getting a little crazy. Y'all, I had a teammate during this madness. We were on the market for the weekend. We got like 40 offers. 40 offers. These offers are 17 pages each, plus all the RPODs and the MOG and any applicable addenda, right? So you're basically sending your seller, what's that, like a ream of paper, saying, look at this and let me know what you think? Is that how we present an offer? Is that how we old car? No, we got to help the seller go through those offers, that ream of paper. And one trick that was coming out that I love, agents were creating like an Excel worksheet. And they were like, here's offer one, and here's the term: price, due diligence, earnest money. Offer two, offer three, offer four, offer 26, 29. So that way we had everything in a nice side-by-side comparison. Just a suggestion, but I'm just saying, when we're delivering multiple offers, sometimes it gets a little crazy. And we got to help our sellers, listing agents. We have to help our sellers sort through and decipher that. Another thing about multiple offers is we can't shop offers. In other words, I can't pit buyers against each other. As the listing agent, you know all the offers you have in your hand. We're going to learn in just a second that I cannot disclose the terms of those offers without the offeror's permission. More on that in just a second. Again, with that being said, other agents are going to call you and they're going to ask you, what's the highest price offer you have in your hand right now? As the listing agent, can you answer that question? Not unless you have permission of the person that made that highest priced offer. There's no commission rule preventing them from calling you. The commission rule addresses how we respond. So when you get that call, what's the highest priced offer you have in your hand right now? Our answer is, you need to tell your buyers to bring their best and final offer, submit what they're comfortable with, and we'll take it from there. I cannot share that information with you. I think a lot of agents got themselves in trouble. Not that they were intending to shop offers, but just they were caught off guard. So we know the old trick, when somebody calls you and asks you a question or whatever, count to 8 before you respond. It's amazing what 8 seconds can do for you. So breathe and count to 8. What if you are an agent that has 2 buyers interested in the same property? Oh, doesn't that sound like fun? That gets real tricky. Well, remember old car. Remember, I'm a fact finder. So I provide the information for who to make the informed decision? Not me, them. So I'm going to say, here's one CMA. I'm going to pull the same CMA for both buyers. And I'm going to say, this is what the CMA means, and this is the information. What would you like to offer? I'm going to help them decide what their offer terms are. I'm not going to influence them. And I'm definitely not going to share. Both of them are my buyers, but I'm definitely not going to share. It's not like I'm going to say, well, the Smiths are offering this, the Joneses are up to this, right? We're not going to pit them against each other. That's what we mean by shopping offers. We can't pit consumers against each other to drive up prices, or offer terms, we should say. The commission rule, again, 58A.0115, you don't need to know this. I just have it here for reference. And this is the commission rule that says, I cannot disclose the terms of the offer without the offeror's permission. Who can remind me who the offeror is? Do not say buyer. Yep. The offeror is the giver of the offer, the one giving the offer, the creator of the offer, the one submitting the offer. That's right. Maybe this is your buyer making an offer to the seller. Maybe the seller has countered and now your buyer's the offeror. Again, please don't get bogged down, offeror, offeree, buyer, or seller. The offeror is the giver of the offer. The offeree is the receivee of the offer. And we cannot disclose the terms of the offer without the offeror's permission. Do you think any offeror in their right mind is going to give you permission to disclose the terms of the offer? I wouldn't, would you? Absolutely not. If they do give you permission, I would get that. You need to get that thing in writing. I need you to document the heck out of that conversation. Questions on multiple offers? Contract modifications and counter offers. Again, we've referred to this, just kind of finishing up. Any change to an offer is a rejection. I don't care how small and insignificant it should be. A rejection kills an offer. A counter offer is a rejection. Counter offer is just a rejection with a but. I'm good with all these terms, but I want more due diligence and earnest money. We're now in the throes of negotiations. Numerous changes if we're going old school and we're countering on the actual physical paper itself. We're crossing through and making the change and everybody initial and date. After a while, you guys saw the offer to purchase and contract. I don't have a lot of room in the margins to write, do I? And after a while, that's going to get cramped. So we may just want, if it gets to be that our changes are making the offer or the contract hard to read, just do a novation and draw up a new one where everybody can read it. And then this third bullet point kind of piggybacks off of what we already know of document what? Everything, and that includes all offers. My guys, my teammate, what I say, 40 some offers, let's just say 40. I don't remember the exact number, but it was in the 40s. Let's just say 40. Of those 40 offers, how many can we accept? Yeah, just one, which means I had 39 rejections, right? Think about that. Can only accept once, which means 39 people were told, thanks, but no thanks. All those other offers had to be documented. Document everything. You guys will have transaction files. Many of you will have platforms, and it's so easy to store. Uploading a PDF is all you got to do to store, and it keeps you in compliance. It keeps your firm in compliance. Copies of the offer. Eventually, everybody needs a copy of it. Once upon a time ago, when we were signing on paper, we might have two versions, the exact same thing. It's just one version has the seller signature and another version has the buyer signature. It's the same thing. I just got two originals. Today in the e-world, it's a lot easier. We can handle more just with one copy, one original. When we go under contract, both agents, listing agent and selling agent, need a copy of the contract. Buyer and seller need a copy of the contract for their records. I don't know if we've talked about this one yet. How many days do I have to deliver instruments? Must have mentioned it. Yep. We got 3 days to deliver all instruments. So if we go under contract today, if I get everything signed in a contract form today, that means I have 3 days to deliver a signed copy to my buyer or seller, to my client. Again, I have to ask the rhetorical question, is it taking you 3 days to send an email with a PDF attachment, right? It's that easy today. Hey, buyers, congratulations, your offer got accepted. The contract is attached. I'll be in touch soon with the next steps. Buyer's agents. You also need to make sure that you send a copy of the offer to the lender. Buyer's agents need to get a copy of that signed contract, executed contract to the lender so they can start their thing. Once you send a copy of that to the lender, buyer's agents, I need you to send a copy of the contract to the closing attorney so we can go ahead and get settlement on the books. Maybe it'll be delayed, maybe it won't, I don't know. But right now, as of contract day, I'm trying really hard to make it happen on the settlement day that we agreed on. So we can go ahead and get that scheduled, get that in the books. And the attorney needs the contract to start their title, public record search, their process. So both parties, buyer and seller, both parties' agents, if they're represented, the lender, and the closing attorney. And again, this e-programs, this is just addressing more how it's done today. I don't want to say paper's gone away. We're not one of those industries that paper's gone away, unfortunately, yet. For example, a lot of closing attorneys require wet signatures on the closing documents. A wet signature is putting paper to pen. I think that's starting to loosen up a little bit. Some closing attorneys are allowing e-signatures, but for the most part, that piece of the process is still going to be paper for the most part. As far as the listing, the agency paperwork, the contract paperwork, that can all be E now. So that's good. That's helpful. Questions? So we're going to walk through a scenario, this magic moment in time of when it goes from being an offer to a contract. And before we walk through it, let's quick refresher. There's two things that have to happen. There's this definite moment in time when we went from it being an offer to a contract. And that definite moment in time is defined by two things. The first thing we need is the last offeree to accept. What do I mean by accept? They have signed. Does everybody hear me? When you see it's accepted, know that it's been signed. Step one. And then the second step we need is communication of acceptance to cross the line. In other words, the person making the offeror has got to know that their offer has been accepted. So two steps. So with that in mind, let's walk through a scenario. And you guys, I'm going to ask you some yes, no questions. So you guys are going to shake your head yes or no as we go through these. And we're going to define, when does it go from being an offer to a contract? What's that magic moment in time? So the buyer offers a purchase price of $150,000 with $250 in due diligence, $250 in earnest money, $1,500 in closing costs, and a closing date in 3 months. They want a home warranty, and of course, they want the refrigerator. Shake your head, yes or no. Are we under contract? Nah, we're just getting started, right? The buyer's made an offer. The offeror has submitted an offer to the offeree. What are the offeree's three choices? They can accept it, reject it, or counter it. So the ball's in the seller's court right now, yes? They have three choices: accept it, reject it, or counter it. So the seller counters. They say, we're good with all the terms, except I don't want to play closing costs. You're not getting my refrigerator and 6 weeks to closing. So what we mean by this, it means we're good with the purchase price. We're good with the due diligence. We're good with the earnest money. We've closed the gap a little bit. We've agreed to some of the terms, but we haven't agreed to all of the terms. Now we're still negotiating with the closing cost of refrigerator. I guess they accepted the home warranty too. So the closing cost of refrigerator and the time to closing. So the seller has countered. Shake your head, yes or no. Are we under contract? Nope. They threw that ball right back at the buyer, didn't they? So now the buyer has three choices. They can accept it, reject it, excuse me, or counter it. Nobody is bound until we have acceptance. We can throw that ball back and forth all day long until we have acceptance and communication of acceptance. So seller counters, zero closing costs. You're not getting my fridge in 6 weeks to closing. All other terms are acceptable. Buyer accepts. Stop. What's that mean? Buyer has done what? They have signed. Buyer accepts the terms of the seller's counter and tells their agent to go for it. The buyer tells their agent to go for it. Yes or no? Are we under contract? About 50-50 now. Let me ask you this. When the buyer tells their agent, did communication cross the line? Are we still on the same side as the line? The buyer tells their agent. Who's standing with the buyer? The buyer's agent. So just because they tell their agent doesn't mean that that communication has crossed the line. We're still on the same side of the line. We're not under contract yet. The selling agent calls the listing agent and says, my buyer's accepted your seller's offer. Now are we under contract? Congratulations. We are under contract. That communication has crossed, whoops. There it is. That communication has crossed the line. Buyer accepts it, which means they've signed. Quick picture. So you got the buyer. We know the rule of the offer or offeree bouncing back and forth. But in this case, the final buyer accepts it when they tell their agent that communication did not cross the line. We're still on this side of the line. Once the selling agent contacted the listing agent, that's when that communication crossed the line. And congratulations, we are under contract. Questions? Another question for you guys. So set your chats, if they're not already, set your chats to private. And in a private chat, tell me A, B, C, or D. Just a couple more seconds. I'd like to hear from everybody. Let's see what we got here. Sunday, the listing agent receives a written offer for 145 on a house listed for 154.9. On Monday, the seller counters at 149.9, gives the buyers 3 days to accept. Wednesday, the buyer rejects the offer, and upon being informed, the seller says he will accept the buyer's original offer. Under these conditions, what do we have? We don't have much, because once that counter offer was made, it rejected the offer. A counter offer is a rejection. Once it's rejected, there is no going back. A counter offer kills the original offer. Nobody is bound until we have acceptance and communication of acceptance. So when the buyer, let's see, when the buyer rejects the counter, the seller says, no, 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 no. Okay, I'll just go back and accept the buyer's original offer. They can't do that, because when they countered it, they rejected it. Now, let me ask you this. Could the seller make a brand new offer to the buyer with these exact same terms? Yeah, absolutely. I can't go back and revive, but we can start over. So in this case, if this is what we want to do, then we would just need to present a brand new offer. Questions on this one? The last piece of Unit 10 is our alternative land conveyances. We're going to introduce you to a couple different methods for conveying property. Not all of them, of course, but just a couple more commonly ones that we might see. The rest of this unit is all green stars, which means we just need a very basic understanding of the different methods. All green stars, very basic. Is everybody good if we boogie on through this pretty quickly? You might see a test question or two, but I don't want to get bogged down. I don't want to spend a lot of time on this, so we can get back to yellow and red star stuff. Fair enough? All right. First alternative method for conveyance is something called an installment land contract. And with an installment land contract, the buyer is paying the seller, but they're not doing it in one lump sum. They're doing it in installments. Think of an installment land contract as buying a house on layaway. You make all the payments, and once you make that last payment, you get the product, right? Same thing here. You're buying a house on layaway. So the buyer's making the payments directly to the seller. The buyer has equitable title. They have possession. They can live there. They can use and own the property. But the seller is going to keep that legal title until that last payment has been made. That's your pickup from the layaway department. Once you make that last payment, you go pick up your deed. So an installment land contract. By the way, when we get to Unit 14, we're going to talk about seller, or 15, we're going to talk about seller financing. And we're going to compare seller financing to an installment land contract. I'll tell you right now, the difference in the two, also known as, the difference in the two is when the deed changes hands. So with an installment land contract, the deed changes hands when the last payment's made. With seller financing, the deed changes hands at closing. So the installment land contract changes hands when that last payment is made. The seller gets to keep the title, the deed, up until then. Buyer agrees to purchase real property, pay the seller the sum of $105,000 in the following manner. We're going to do $5,000 at the execution, balance of $100,000 plus a 12% interest rate paid in full. Principal and interest shall be 240 installments of no less than X amount per month beginning on this day. So it sounds very much like dealing with a lender. You're going to charge me an interest rate. You're going to pay this payment on this date for X amount until it's paid in full. In a sense, the seller's acting as the lending institution, and that sense being that the buyer's paying the seller directly. We're not going through a lender. Pluses and minuses to everything. Some seller advantages and disadvantages with the installment land contract. The seller still owns the property. The deed's still in their name. So they may be able to take advantage of some tax benefits. For the seller, this may make a hard to sell property a little bit more desirable. We're kind of opening our pool to other buyers. The big advantage to the seller is they keep that legal title until it's paid in full. If the buyer, we're going to learn in a second, if the buyer stops making payments, then the seller still has the deed. So they could start the process of getting them out of the property, going through all that. We're going to talk about how you get somebody out of your home when you're the owner. That's coming in our landlord tenant section. So they have to go through that process, but at least the seller has the deed. So in the event of the buyer default, the seller's the one with the document that can proceed. The big disadvantage to the seller, obviously, if the seller needs the whole purchase price right now, then they're not going to be able to consider this. They're going to get paid. They're just not going to get it all in one lump sum. So if the seller needs the money right now, that may be a disadvantage. They may not be able to consider it. Pluses and minuses for the buyers. This could be a good advantage to the buyer if their credit's poor and a lender doesn't want to give them credit, but maybe the seller's willing to work with them. You know, not all poor credit is a sign of of people that can't handle their bills? What if there was some recent medical issues, for example, right? So it might be that the seller's willing to work with them where the lender can't. And then the buyer's the one living there. They're probably the one paying the annual taxes. So they too may be able to take some tax advantages of the property. Remember, you guys, unless you're an accountant, do not give tax or accounting advice. So when you're buyers and sellers, we want to advise them to talk to their accountant to find out about these tax advantages. Disadvantages to the buyer. If the buyer defaults, that's a big disadvantage. So the buyer defaults means they miss a payment. The seller has to give them 30 days to get caught up. If after 30 days they're still in default, the seller can call the whole note due. And if they can't do it, they can't do it. This is over, and now you got to get out of my house. Again, there's legal measures on getting this buyer out. We'll talk about that. And another big disadvantage to the buyer, they don't own the property yet, so they can't use it as collateral. Both parties may have a little higher attorney's fees. You know, think about it. What did that, I'm going to go back for just a second. What did this say? 240 installments, that's 240 months. What if the seller put some kind of lien or some kind of encroachment, let's say a lien on the property during those 240 months? Isn't the buyer going to want to know that before the deed changes hands? So we're probably dealing with attorneys up front when we're creating this thing. And we probably got to deal with attorneys one more time at the end after 240 months before that deed changes hands. Have that attorney do that public search of the records, all that good stuff. We do not have a pre-printed form for an installment land contract in North Carolina. We do not have a pre-printed form available. So if your buyers and sellers are considering an installment land contract, what are we going to do? Got to get attorneys involved, right? I can't sit down and draft this up for them. So if we do, like I said, we get attorneys involved in the beginning, and we literally need them to draw up the terms, draw up the contract for the installment land contract. Listing agents. If an offer comes in to do an installment land contract, do you have to present that to your seller? Shake your head yes or no. Do you have to present it? All heads should be shaking yes. Why? Because which offers do we present? All of them. And an offer to do an installment land contract is an offer. Questions on installment land contract? Another alternative land conveyance method is the option to purchase real estate. The option to purchase is our one example of a unilateral contract. In a unilateral contract, how many sides have to perform? Unilateral. Just one. Just one. Remember, lateral and contract world means side. Uni is one, bi is two. So a unilateral contract, there's only one side that has to perform. So here's the deal. With an option to purchase, the buyer has made no promise to purchase. They have simply requested and been granted the option to decide if they want to purchase. When we enter into an option to purchase, we agree to all the terms like we always do. In this case, the buyer's saying, if I decide to buy your house or your property, I will do so at X amount, purchase price, due diligence, earnest money. We've got to agree to those terms before we enter into the option. We also have to decide on the option period. So the buyer has an option of 2 weeks, 2 months, 2 years, whatever the parties agree to for their option period. At the end of an option period, the buyer has a decision to make. They either agree to buy your property at these terms or they don't. If they agree to buy, we have moved into a bilateral contract. If they agree to buy, we have moved into the contract that you and I are familiar with. All we're doing with this is giving the buyer the opportunity to explore the option. Another thing that makes an option to purchase very unique, we don't just have one form of consideration. We have two forms of consideration. We've got to have two forms. First is that agreed upon sales price. Remember, we're negotiating everything. If I agree to buy your house, these are the terms that I will buy them on. So we've already got the sales price agreed on. The other thing answers the question. I know some of you are asking yourselves, why would a seller agree to give somebody an option for 2 months to decide if they want to buy my house or not? And the answer to that question is money, money, money. The option fee is usually pretty generous and pretty healthy. The buyer is paying the seller to not sell their home during this time. That is the unilateral piece of it. The buyer's made no commitment. The buyer has no promises. The only promise made in an option to purchase, the seller promises not to sell it to anybody else during this time. The buyer's locking the seller down. Again, at the end of the option, if the buyer doesn't buy, both parties go about their lives. The seller's collected the option fee, their time to keep their property off the market. The buyers explored their option and decided not to buy. If at the end of the option period, the buyer does agree to buy, that option fee will be credited back to them at closing. Don't confuse this with the due diligence period. With the due diligence period, we have a legally binding bilateral contract. The sellers agreed to sell, the buyers agreed to buy. The option to purchase is a unilateral. I'm deciding if I want to buy. The only promise made is the seller can't sell it out from underneath us. I, once again, do not have a pre-printed form for this. So what do we need to do? We got to get attorneys involved, listing agents. If you get an offer for an option to purchase, do you have to present it to your sellers? Everybody, shake your head yes, because an offer to do an option is an offer. Question comes in, is this common? I think this is more common in the commercial piece of it. I do think it comes up in the residential. I heard about it in residential in that crazy multiple offer world. People were coming in town for the weekend to see property, but they knew what was listed today wouldn't be available by the weekend. Things were moving that fast. They knew things that were listed on Thursday may not be available for the weekend. So they were trying to, in some cases, do some options to kind of lock the seller down until they could get here and see the property. In commercial, let's say you work for commercial or corporate, I should say, corporate USA, and they want to open up a new warehouse in Raleigh, and you're tasked with finding that warehouse in Raleigh. And you go down and you find two that could work really well, but you want time to decide, you want time to explore which one is the best. We could enter into an option with both of those warehouses. Again, how long is it? Is it 2 days? Is it 2 weeks? Is it 2 months? Is it 2 years? It's all negotiable between the buyer and the seller. But we could enter into an option with and have that time to explore. Will the optionor always be the seller? Yes, in this case, because they're the giver of the option. They're the giver of the option. By the way, both the installment land contract and the option to purchase, remember, I don't have forms, so we got attorneys involved early, like from the onset, right? We can't form a contract without having an attorney draft something up. Both of these, the installment land contract and the option to purchase, are going to have to be recorded. Connor Act says they need to be recorded because we got to prevent the shady seller from selling it out from underneath the buyer. Does that make sense? If we're in a 2-month option and your only promise to me is that you can't sell it within those 2 months, I don't know you. I don't trust you. I don't trust that you won't sell it out from underneath me. So how can I protect my interest as the optionee? Put this thing on record, So if anybody goes to buy in the next 2 months, the closing attorney will find this and they will see that the seller is locked down. Questions on the option to purchase? And the question about is common. I mean, I think the lack of pre-printed forms, I think, is part of what makes us question it. But honestly, these things are so not that them in themselves are unique, but the terms themselves are unique. So we can't have a pre-printed form because a lot of those pre-printed forms wouldn't fit this situation. So the best thing to do to protect all parties, both here and the installment, is to have an attorney draft something up. And that way we make sure everything's being done not only right legally, but also according to whatever the parties agree to. Questions? I got one more alternative land conveyance method to talk about, but we got to take a break. So let's take 10. And we come back, we're going to talk about something called a preemptive right. And then we're going to wrap up unit 10.
Press 2. For prescriptions, your call is being recorded for quality assurance purposes. Please hold, and your call will be answered in the order it was received. Stay connected with Novant Health through our new texting service. Simply text the word START.
We can hear you. You're unmuted.
Lewis, how can I help you? Hello?
Hi, hold on a second. Hi, this is Debbie Jackson. I need to schedule an appointment today.
Can you verify your date of birth?
2769. I need a post-op appointment to be seen today for May. I did last Thursday.
Okay. Because I have it 2 weeks from May 2nd.
Yes, I
I am taking attendance. The last alternative land conveyance we're going to talk about, I got two different types of preemptive rights. Before we look at that though, let's talk about what a preemptive right is. And a preemptive right is just a contractual right to acquire property before somebody else. So if we've entered into a legally binding agreement that says you may not want to sell right now, but when you are ready to sell, you're contractually obligated to come to me. Maybe it says I'm not ready to buy right now, but when I am ready to buy, I'm contractually obligated to come to you. So we have these preemptive rights, which puts parties in the first position, if you will, when it does come time to buying or selling. The first preemptive right is the right of first refusal. And with this one, the owner promises a contracting party the first chance to match a bona fide offer, which means a legit offer. It's a ready, willing, and able buyer making a serious offer. And before we can respond to that offer, preemptive right of first refusal says, I got to come to the preemptive right contracting party first and give them the option to match that. Right of first refusal is not a promise to sell. It's just a promise that I will come to you first and see if you want to match this offer. Think about maybe you live next door to a corner vacant lot and you have no interest of buying that corner vacant lot. However, you don't want Dollar General to buy that corner vacant lot either. So you enter into a right of first refusal with that owner of the lot. Now that we have this preemptive right, if Dollar General comes and makes an offer, they're contractually obligated to come to you first because you have this right of first refusal. The other preemptive right, and I'll do a side-by-side comparison as well, so we can see the difference. But the other preemptive right is the right of first opportunity to purchase. With these, we have agreed to a price. So we have said, if we enter into this first right of first opportunity to purchase, we're going to decide how much I want to offer you. And again, maybe the seller doesn't want to sell, but with this right of first opportunity to purchase, when they do decide to sell, they're contractually obligated to come to me first. Remember that offer you made me some time ago? Here's your opportunity. Here's your chance. If you say no, I'm not interested, either one of these. If you say no, I'm not interested, then the owner is free to sell to whomever. All we're saying with the preemptive right is they're contractually obligated to come to you first. The big difference in the two, here's our nice side-by-side comparison, comes down to negotiating the price. With the right of first refusal, I don't know what I'm going to offer you, but what I know is I have the right to match that bona fide offer. With the right of first opportunity to purchase, this is what I'm going to pay you when you decide to sell. So I say they're both preemptive rights, and that would be the big thing to focus on. But the big difference of the two comes down to when we decide on that purchase price, sales price. Another alternative land conveyance, probably the one that we see most often out in the wild, I'd say, is a lease to own situation. You may have a 2-year lease to own, for example, situation. So you have somebody living there and paying rent, but part of that rent is going towards the purchase price. I think lease to owns are more common with the tenant when the tenant is in place. Again, though, we don't have pre-printed forms for any of these. Same thing with the preemptive rights, no pre-printed forms. So we just need to, anytime we're dealing with these alternative land conveyances, a little red flag goes up because there's a really good chance we got to get attorneys involved to draft up this paperwork. Questions? It gets us through 10. Those key terms are back on page 271. Key point review. Again, the key point review is not a supplement to the unit. I treat it as your Cliff's Notes, kind of the abridged version. And then your student quiz, and you got some quizzes in the online learning system as well. And don't forget too, you guys, I'm such a believer in the power of repetition. So the more you hear this stuff, the better it's going to click. So please make sure you're taking advantage of our YouTube channel, watching those videos. How many of you are watching them, listening to them? Y'all sick of hearing from me? I bet. Just a few more months. But please make sure you're taking advantage of that. The first time you hear it, first time you see it, it may mean something, but you're not ready to pass a test on it. Second time, third time, that's that power of repetition. What questions do we have? Help me remember at break. Help remember at break, and I'll put the link to the YouTube channel in the chat. My, how the tables have turned, right? All right, the last thing I want to do in 10, y'all put your pencils down for just a second. I just want to get your minds thinking a little bit. So we've talked about this contract formation wall, and the example we've been giving pretty much looks like this. You got two different firms, although we haven't said it. The example we've been given is you got two different firms, one working with the buyer, one working with the seller. Buyer makes the offer to the seller. The seller is the offeree, has three choices. They can accept it, reject it, or counter it. Seller accepts. Communication of acceptance crosses the line, and congratulations, we're in a contract. I feel fairly confident for your exams. This is the scenario you're going to see, where buyer and seller are represented by two different firms. Again, I encourage you guys to draw the contract formation wall on your exams. Have you guys seen some of those practice questions yet in the online learning system? And those questions are like this long, and you got to read like half a page to try to decipher. And for me, one of the easiest ways to decipher this information is to draw a picture. And that's what we're doing here with the contract communication, contract formation wall. So this is what we've been seeing. This is the scenario that, like I said, I'm pretty certain you're going to see on your exams. With that being said, I want us to start thinking about how agency, different types of agency, can affect this line, this contract communication wall. In dual agency, how many firms are in dual agency? Just one. So when agents are involved in dual agency, there is no contract communication line, wall, because once you tell something to me, you've told something to everybody in the firm, haven't you? That's what dual agency says. So once you tell the firm, we have acceptance, the seller has accepted, and then that communication, once you tell the firm or the agent, communication has been delivered to the buyer. There is no contract communication wall, because dual agency is all and only about the firm. Designated, that wall comes back. The firm and the agent are still straddling the wall, but now there's two agents on either side. There's one agent that's been kicked off the wall to work exclusively with the buyer, There's another agent that has been kicked off the wall to work exclusively with the seller. Once we go into designated, that line, that contract communication line comes back. So now the buyer makes the offer to the seller accepts it. The seller calls their agent and says, I have signed. And then that communication of acceptance has to cross the line to the selling agent. So very similar. I'll have to look at that too. The other scenario, that contract communication wall and dealing with agency, is when we're dealing with seller sub-agency. Remember, with seller sub-agency, the buyer is unrepresented, which means they're hanging out all over here all by themselves. Everybody else, the firm, the seller sub-agent, maybe the seller sub-agent is with the same firm, maybe they're with a different firm, doesn't matter. Because they're the seller sub-agent, they are allowed to hang out on this side of the wall with the seller. So in this scenario, how it's probably going to look, the buyer makes the offer to the seller has three choices. They can accept it, reject it, or counter it. The seller accepts it. They're going to communicate with the listing agent. They're going to communicate with the agent that they've been working with. Did that communication cross the line? Then the listing agent is going to communicate with the seller's sub-agent. Again, maybe we're with the same firm, maybe we're not. Did communication cross the line? Not. Now we need a third step in this, don't we? Now we need the seller sub-agent, who is the one that has been working with the unrepresented buyer. The seller sub-agent is the one communicating with the buyer. They're just not hanging out on the same side as the buyer because the buyer didn't hire them. So now the listing agent calls the seller sub-agent. Now the seller sub-agent calls the buyer. Now did our communication cross the line? Yes. So again, it's still both parties, both agents, I should say, both firms, both agents, but this is just how that contract communication line can vary with the different types of agency. Again, I feel so comfortable standing here in front of you guys. Your test question is going to deal with two different firms, and just get your hamsters running, get your gears turning first thing this morning. What questions do I have? Okay. Let's talk about your application for your state exam. So first off, we're in the online learning system, and in the welcome section, there's a book called, what's it called? Real Estate Licensing in North Carolina. You guys know in real estate, we like to, if we can make an acronym out of it, by golly, we're going to. So the Real Estate Licensing in North Carolina booklet is often referred to as the RELINC book, RELINC, Real Estate Licensing in North Carolina. You guys got this booklet, this book, a PDF version, when you signed up for this class, and Lane sent you an email with the information you needed. You guys got this booklet then as an attachment, and I know Lane asked you guys to read it before class. I'm just curious, how many of you looked this over before class? A couple of you? Good. This is the booklet that answers the question. Yay, I passed Julie's class. Now what do I do? This booklet picks up where you and I leave off. Okay. The email you got from Lane whenever you registered, there's a good chance that the booklet you got in your email is out of date. The current, as with any form, you guys, the current will always be in the online learning system. So they last just updated it in March. If you have the email with the older version, just discard that version and make sure you come to the online learning system. And again, I'm in the welcome section for you to access it. What we're going to do is we're going to go through this booklet, talk about the process of getting your license, what you need to do. I ask a couple things of you guys in advance. First, hold off on all questions. There's a really good chance the answer to your question is somewhere in this booklet. So give me just a minute. I promise you I will leave time open at the end for your questions if we didn't answer them. The second piece of this booklet, this is only pertaining to your state exam. Please do not ask me about our end of class exam. This conversation is only about your state exam once you leave this class. We will talk about our end of class exam as well, but right now we need to keep these conversations separate to try to avoid mixing them together. So you have these PowerPoints. They're also in our Julie folder and the online learning system. Not only does this booklet kind of walk you through the process, it's just an out-of-date slide. But not only does this booklet walk you through the process, but there's also some testable material in here. We're going to talk about a couple things on license law and commission rule that we will get to when we get to that section. But by reading this booklet, you can get not only the answers you need, but also some good test questions as well. So this booklet kind of starts with the requirements of a license, which we've already seen. And we said that in order to have a license, all three of these things must be present. So the transfer of real property for others for compensation. Don't translate that just to money. Any form of compensation. And if all three activities are present, then a license in North Carolina is required. So I think the example we gave, we saw this back in Unit 8, and the example we gave is if you're the for sale by owner. And if you're the FSBO, you're no longer doing it for others, you're doing it for yourself. So does the FSBO need a license? No, because we have to have all three pieces. We have to have all three pieces. What if your sister wants to buy a house and she says, I'm not giving you anything. You will work for me for free. No form of compensation. She can't even take you out to lunch. Can you help your sister for free? Totally free? No compensation whatsoever? Sure, you don't need a license to do it because, again, all three pieces are required. Y'all don't work for free. If that's your plan, call me. I will talk you out of it very quickly. I'm at least going to get you lunch, right? But we're getting the point here, right? Any form of compensation, anything, no matter what, all three pieces are required. North Carolina is a brokerage state, which means we are all brokers. Some states have sales associates, and then you graduate into brokers. North Carolina, we skip that sales associate mess and move straight into brokers. What makes us different are the license categories. We know you guys, soon to be you guys, my provisional brokers, my PBs. This is the entry level status. Provisional brokers is the entry level. Other states that have sales associates, this is basically what they are. They're an entry level status. Again, we just skip that sales associate mess and go straight to brokerage, but we're going to put you guys on entry level status. I call my PBs my brokers with training wheels. Y'all can ride your bike as a PB, but you can't do it without your training wheels. And who's your training wheels? The BIC or the firm. As a provisional broker, you are not active until you're affiliated with a broker in charge, until you're affiliated with a firm. More on this when we get to our license law and commission rule. To drop the provisional status, you have to complete 90 hours of post licensing. That's all you have to do to drop that provisional status. There's 3 30-hour classes. Maybe you do all three within your first month of licensure. Maybe you do one a month, whatever. Doesn't matter how you do them or what order. But once you complete those 90 hours of post licensing, your provisional status is removed and you are just a broker. Also referred to as a full broker. By the way, can anybody remind me how long you have to complete post licensing from licensure? I'm not sure if we talked about that or not. Give yourself a little bit more time. The number's right. Almost. Yeah, yep, there it is. So you guys have 18 months. 18 months from licensure to complete your 90 hours. When you get your license, there will be a date on your license. You'll get it in the mail. Get a nice 8.5 by 11, get a frame for it, display it, hang it. Y'all worked hard for this thing. Be proud. So you get a license in the mail. That license has a date on it. That date starts your 18-month clock. Again, I don't care what order you take posts, and I don't quite frankly care when you do it. Just get it in before your 18 months. Post 90 hours drops your provisional status. You're just a broker. At some point in your career, you may want to be the boss, in which case you would be the broker in charge. You would be above others in your firm or your office, I should say. We're going to talk about the BIC. We're going to talk about each of these license categories more in depth when we get to license law and commission rule. Just introducing them to you now because they're addressed in the RELINC book. So we got them in your RELINC book. We also got it in license law and commission rule. So we'll say more about it. The other thing to know is that the firm also has to have a real estate license. The firm is treated as a person, except the fact that they're an entity. So the firm has to follow the same license law and commission rule that the individual brokers do. They got to follow the same rules. They got to renew every year like we do. All that good stuff is coming. But the firm is also a licensed entity. So how do we get licensed? Well, this is what this book, the main part of this book, is about. First off, a couple qualifications. You got to be 18 years old to have a real estate license. You can take this class when you're 17. And I would suspect I may have some 17-year-olds or awfully close to you in this class. You got to turn 18 before you get your license. You got to be a U.S. citizen with a social security number. You got to satisfy the education requirements, which is what you're in the throes of doing right now. We're going to look at the steps, and you guys are in the throes of step 1. You got to submit your application, which we will talk about. You got to pass that 2-part exam. And then you got to prove to the commission that you have the character that they're looking for. That comes in the application you're going to submit. You got to prove to the commission that you have the knowledge to go out there and help buyers and sellers. How do you prove that to them? You pass the 2-part state exam. So you prove to them that you have that knowledge, that competency to go out there and get started. They're going to let you go out there and get started knowing they got more education and training coming your way. Yes. A U.S. citizen to have a license. Yes. Make a note in the RELINC book, starting on page 7. It goes through the application process, and it is a step-by-step process. Hear me when I call it a process. And you go and order the steps. I'm not going to lie, the number one call Lane and I get is because you guys are trying to go out of order. You're trying to do something. You're trying to do step 4, but step 3 is complete. So we got to go and order the steps. We got to go through the process as they are. Y'all consider this. I've heard a couple years ago, the Real Estate Commission said they were dealing with about 1,000 applications a month. Now they're down to about 800. So we're getting, down a little bit, but think about that. 800 applications a month from across the state. If you're not doing it the way they want you to, they don't have time to deal with that. This is why they have this booklet. This is why they have this process and these systems in place, so they can speed things up if everybody follows the steps. So step 1 of the application process, complete this course. We're in the throes of step 1. Once you pass the end of class exam, any school, once you pass a end of class exam, the director of the school, in our case is Lane, will send you a certificate of completion. Your certificate of completion is good for 3 years, which means when you finish this class or any class, you have up to 3 years to go pass your state exam. Please, please do not wait 3 years. Please don't wait 3 years. License law and commission rule changes. Forms get updated. You will always be tested on the current material. So if we finish in May and they update a law the next day, that's what you're going to be tested on. Does that make sense? So the longer you wait, the more things change and you're less familiar with the testable material. I also don't think you guys want to wait 3 years, because I'm telling you, when you put this stuff down for 2.5 years, all that information you learn kind of goes somewhere. I don't know where, but it goes out there in the atmosphere, and you're pretty much starting from scratch. So what I suggest, a couple things: go with a state exam only when you're ready. I'll talk more about that in a second, but submit your application, go to the state exam only when you're ready. Don't wait 3 years. And everybody promised me, that's a long time. Y'all know how many calls I get from former students? Julie, I was in your class in 2022. You remember me? I remember your face, maybe not so much your name, but I will remember your face. Okay, so I took your class 2 years ago, and now I'm ready to go to the state exam. What should I do? And you know how I respond? I send them the link to my current YouTube channel. And I say, if you haven't touched this stuff in 2 years, you gotta start over. Everybody hearing me? Head bobs of acknowledgement. The longer you wait, the more you lose it. Okay, so certificate of completion is good for 3 years. Once you get that certificate of completion, you can submit your application on the Real Estate Commission's website. We're going to go out there in just a minute and look at it. We're going to go out and I'm going to show you where you hit the button. You can start your application process now. We'll talk about that, but you cannot submit it until you get that certificate of completion. Step 2, submit your application. But again, I'll show you guys in just a minute where you can access it, because you may want to start. Once you submit your application, the Real Estate Commission staff processes your application. If it's not complete, they're going to send it back to you. So take the steps, take the effort to go through that RELINC book when you're applying. It walks you through the different fields, what you need to put in. So use that RELINC book as your guide. The Real Estate Commission processes your application. And if they say so far so good, step 4 is they're going to send you a notice of exam eligibility. The notice of exam eligibility is your ticket into the state exam. You cannot go. The testing center doesn't know you exist until you get your notice of exam eligibility. So if you want to expedite the thing and call the testing center before step 4, they're not going to be able to help you. Remember, we got to go in order. So upon approval, the commission sends you your notice of exam eligibility. This is good for 180 days. Certificate of completion is good for how long? 3 years. Notice of exam eligibility is good for 6 months. Once you receive your notice of exam eligibility, you have 6 months to pass both sections. Again, this is why I want you to wait to submit your application when you're ready. Notice of exam eligibility is good for 6 months. If you don't pass both sections within 6 months, you have to start over with the application process. Remember, your certificate of what do we call it? Certificate of completion? Is that what we call it? Okay, certificate of completion is good for 3 years. You don't have to retake this class until that certificate of completion expires, 3 years. But you do have to submit a new application if you don't pass each section within 6 months. I'm going to talk about going to the testing center and fees and all that good stuff. So you've received your notice of exam eligibility. Now you contact the testing center to schedule your exam. As of March 1st, the state of North Carolina has a new testing center called Pearson VUE. That doesn't mean anything to you guys because you don't have anything to compare it to. I will tell you this, we've gotten very, very good reviews about the new testing center. The former testing center had complaints about lack of communication. Students didn't know what they were doing. They didn't have clear instructions. I will say in the last, well, even the first week of Pearson VUE, we're getting really good results, really good reports. So just know you guys are in much better hands now than the guys that tested on February 28th. There's good news. You guys are good. Pearson VUE. You go to the state exam. See, I'm getting questions about our end of class exam. Stay with me, you guys. I promise I'll get to it. Stay with me. You go to Pearson VUE. You take 2 sections. There's a national section and a state section. In order to pass, you have to pass both sections. Once you pass both sections, congratulations. You are now a licensed North Carolina broker. Is that exciting? If you don't pass both sections, you have to keep going back until you do. There's a national section and a state section. Within that 6-month period, if you fail one section and pass the other, you only have to retake the one that you failed. If your 6 months expires, now you got to go start all over. You got to pass both of them again. So again, I say, don't go until you're ready, because as soon as you get that notice of exam eligibility, your 6-month clock starts. Again, so many times you call, let's see, we're finishing in May. So many times from you guys, for example, I'll get calls in like August. I submitted my application in May and now I'm ready to go to the exam. Well, you just killed 3 months. You just wasted 3 months of your time. Everybody with me? I don't know if you'll need the full 6 months, but I know if you let that notice of exam eligibility expire before you pass both sections, there's more cost, there's more time for you guys. So don't submit your application until you're ready. Because as soon as you get that notice of exam eligibility, that clock starts ticking. How many times can you take the test if you fail? As many times as you can to get in within that 180 days. I do know they make you wait 10 days in between. It's like a cooling off period, let you revisit, review. But you can go as many times as you need to while your notice of exam eligibility is good. So the 6 steps, again, 1 step at a time. I'm telling you, this is the #1 call Lane and I get. I called Pearson VUE and they said they didn't have me. Did you get your notice of exam? No. Well, then I know why Pearson VUE doesn't have you. I know why you can't schedule. So refer, again, make a note, pages 7 and 8. These are your step-by-step instructions. I'll get to the questions in the chat, I promise. Part of your application, you will have to order a criminal background check. The criminal background check is part of your application process. So you do it all in the same place. You don't have to worry about going somewhere else. They're only going to accept a criminal background report from one institution. And again, that's all linked in the application. So it's just part of your application process. Your background report is good for 6 months. Some of you are ready. Some of you are ready to do this. And as soon as we finish in May, you're ready to submit your application and go. I think it's too early to order your background report. You may want to wait a couple weeks. Others of you may want to wait until you pass this class and then order your background report. There's no wrong way to do it. But what I'm telling you guys is if you wait, that time, that clock's a ticking while you're waiting on the background report. Does that make sense? But if you go ahead and do it, then your clock is a ticking because it's only good for 6 months. So I do suggest waiting at least a couple more weeks. They're also going to ask you as part of your application about any criminal offenses, whether or not they show up on your background report or not. The suggestion is you just tell them, not let them find out on their own. Just tell them anything. Best to fess up. And guys, just because you may have a blemish in your past doesn't mean you're not going to get a license. It just means that they're going to take it into consideration when they're reviewing your character. Please, please, please do not call Lane and I and tell us what you did. I can't make the decision of whether or not you're going to get a license. Y'all laugh. I'm serious. I can't make that decision. Lane and I cannot make that call. If you do have concerns, you do have, they're looking for criminal offenses, professional license, disciplinary action. How many of you have another professional license, CPA, CNA, anything like that? If you get yourself in trouble with that licensing board, that may be taken into consideration with your character. Well, we'll talk more about that. They're also looking for any liens or unpaid judgments. So if any of this just threw a flag up for you, you have the option to do what's called a petition for predetermination. And the petition for predetermination will allow the commission to review your criminal offense and decide based on that alone, would they issue you a license? You still got to pass a test. You still got to prove other character issues to them through your application. But that petition for predetermination, pages 11 to 13, if this applies to you, that petition for predetermination just answers the question, based on my past, will you give me a license on that? So you don't have to call us. Go to pages 11 and 13. So applying for this exam, remember, you can't do anything. You cannot go until you get that notice of exam eligibility, which is step 4. Notice of exam eligibility is good for 180 days. So it's good for 6 months. As we said, if you don't pass both sections, then you submit a new application. You got to order a new background report. You're pretty much starting over on step 2. At least you don't have to do step 1 again, which is this class. But you're pretty much starting over on step 2, if that 180 days. And guys, listen to me. There is zero extensions granted for whatever the reason. If you're not going to the testing center until day 179 and you don't pass both sections, the commission's going to say, what were you doing the last 178 days? Everybody with me? Don't submit your application until you're ready. 180 days, you got to submit a new application, take that section again. There are costs to get your license. $100 application fee every time you test, whether you're going to take both sections or you're going to take one. $100 application. If you're going to take both sections, it's going to be $160. If you're just going to take one section, it's $150. Every time you walk in that door to the testing center, you've got to pay either $160 or $150. Again, don't go until you're ready. Let me help you save your wallet. This could add up pretty quickly, right? I think so many times you guys just want to go, you're not ready, but you just want to go just to see what it's about. That's your wallet that you're dipping into. So $160 if you're taking both, $150 if you're just taking one. Every single time you walk in that door. The exams themselves. Your national section has 80 questions. Your state section has 60 questions. There's also pre-test questions, or what I call test the test questions. There's going to be 5 questions that you don't get credit for or against. You're never going to know that they're the test questions. But what you're doing with these pre-test questions is vetting test questions for future test takers. You know what past test takers did for you guys? They vetted these test questions. So they're all the time coming up with new test questions, but before they can release them, they got to give them a test. So you'll never know. There's going to be 5 questions that don't mean anything to you. You'll never know if they're the test questions or not. Passing score on each section is a 75. So you got to make a score of 75 on the national section. You have to make a score of 75 on the state section. Score of 75 on both sections within your notice of exam eligibility period gives you your real estate license. Pearson VUE will make accommodations for candidates with disabilities. Page 25 walks you through that process, how you need to communicate with Pearson VUE. They're probably going to want to see your documented paperwork, maybe from your medical, your doctor. I don't know, but look, page 25, it'll walk you through what you need for special accommodations. Maybe you need more time. Maybe you need a space on your own, whatever. Just page 25. Make sure you're following those procedures to get that time or that accommodation. The day you go to the exam, show up at the test center about 30 minutes early so they can get you checked in. Make sure they don't want anything on you, personal effects. So they might give you like a little locker to put all your stuff in, empty your pockets and put your stuff in. I always say the less you take that day, the less you have to worry about. So ladies, maybe just grab your license, you know, and your credit card and leave the purse at home or in the trunk. But if you take it in, you're going to have to lock it up. So the less you take that day, the better. An ID is going to be required. This is important. The name on your ID has to match the name on your application. If the name on your ID doesn't match the name on your application, they may deny you access. They may question if it's you. So when you're filling out your application, make sure you use your full legal name, please. Whatever your license says. If your license isn't right, if the name on your license isn't correct, I suggest calling the, who does it, DMV? This afternoon and getting issued a correct license. Once you get there, again, they are going to make sure you don't have personal effects. They're going to make sure that you, it's all left in a little locker or something. They're not quite patting you down yet, but I have heard students come back from the testing center and tell me that they're required to pat themselves down. So they're not doing it yet, but they may expect you just to kind of just do a quick, just to prove that your pockets are empty. Another big thing about the exam. Yes, the exam is confidential. You guys cannot discuss the contents of this exam or your end of class exam with anybody. If you do, would be considered cheating. And you know, one policy that the commission really frowns upon, one thing that they really emphasize. Come on, guys, let's not cheat. You know how many, I could go on and on and on for stories about people that have gotten caught cheating at the testing center. What do you think that tells the real estate commission about your character if you're caught cheating on the licensing exam? Doesn't look real good, does it? So you've made it all this far, you cheat, and guess what? Game over. It's not worth it. Same thing with my exam, by the way. You cannot share this information. If you do, that could be considered cheating and you would be denied a license. So do not discuss it with anybody. By the way, for the state exam specifically, it'd be really hard to cheat because there's a test bank of questions. And each topic, each category has like thousands of questions. And each time you sit down to take an exam, it's like a random jumble of what 26 questions on agency you're going to get. That prevents you from running out the parking lot and telling me what's on the test. The only thing you can tell me for sure is that you were tested on agency. You know what I've been telling you guys? You're gonna be tested on agency. So what we have, again, the specific questions, if you have to go back, you may not see the same set of questions because that test bank is randomly generated each time. Each section is timed. Do you get 2.5 hours for the national section? You get 2 hours for the state. Once the clock starts within each section, it doesn't stop until it ends. So you start with the national for 2.5, and then you'll start the clock again for 2 hours with the state. The suggestion is take a break between the sections. Once you finish the national section, you complete it, take a break before you go on to the state section. If you take a break during the section, your clock doesn't stop. So if at all possible, try to get through that national section first. And even if you don't need a break, take a break. Get up, walk around, splash cold water in your face, whatever. Just give yourself a second to look away from that computer screen. So like we said, a score of 75 is the passing. They will hand you a piece of paper that says you pass, and then the real estate commission will mail you your license within the week or so. They're pretty quick about that. If you don't pass both sections, then you have to contact Pearson View to reschedule. Again, they make you wait 10 days in between. You can schedule it today, but you got to wait 10 days before you could go back. That just gives you a cooling off period. That just gives you the option to review. You'll get a report. We'll talk about that in a second. You'll get a report that kind of gives you your areas of weakness, if you will. So you know what to focus on, you know what to study. Don't let these exams lead you to believe that these are in any way what type of agent you're going to be. These exams have nothing to do with your performance. Should you go to the state exam on the first try and you don't pass both sections, it's okay. It's okay. You get an opportunity to go back and back and back. What I always say to you guys, if this is something you really, really want, then you will do whatever it takes to get it. I know a guy, y'all, he's a top producer. He is out there kicking butt and taking names. And he would have, because he told me to tell y'all, he would have no problem letting y'all know that it took him 8 tries, 8 times of going to the testing center. And some of you are going, oh gosh, 8? This might have been something he wanted more than you did. You with me? It's up to you. I can't want this enough for you. I need you guys to want this as well. I have no problem in telling y'all the first time I went and took my state exam, I failed. And that was a bad day. I'm not going to lie. It was a bad day. I went out in the parking lot, called mom, because they tell you right then and there. They say submit. You say yes. Are you sure? Yes. Boom. Pass or fail. So I'm out in the parking lot calling mom, because, you know, that's what we do when we're upset. You know, I'm all blubbering in the parking lot. My mom, you know, mom, maybe you did better than you think you did. I already know. You know, it was a bad day. I'm not going to lie. It was a bad day. But you know what? I had my pity party. I picked myself up and I went back and tried it again. And now here we are. Don't let a bad day ruin this career for you. Everybody good? You've got to want this. And if you want this, then this is something you're going to be willing to do. No buyer or seller is ever going to look at you and say, how many times did you take the exam before you got your license? All they want to know is that you have a license. And that's where your story starts. So breathe, pity party, pick yourself up and move on. Lots of top producers have had to take this exam numerous times. Back to passing. No more doom and gloom. When we pass, again, you're going to be handed a license on provisional status. Excuse me. That license is inactive. Congratulations. Here's your real estate license that you can't do anything with. Good job. How do you activate an inactive license as a provisional broker? You gotta affiliate just one at a time. You gotta affiliate with a BIC. Once you affiliate as a provisional broker, once you affiliate with the BIC, your license is active status. As an active provisional broker, you can do just about anything that a full broker can do. The key is you have to be supervised, directly supervised by a broker in charge. And as we said earlier, how you drop that provisional status, you got to do the 90 hours of post licensing. Some people say you got to do it within 3 months. It's up to you. It's up to you. You have 18 months to complete 90 hours. And that's the only requirement. Once you do that, that provisional status is dropped. Yes, there is a test at the end of each post licensing class. To get credit for the 30 hours, you got to pass all 3 of those tests too. With that being said, I'm here to tell you right now that post licensing is not near as intense as pre. Now, with that being said, you still have a test to pass. So I need you to show up and do the suggested activities and readings with post licensing because you got to get through the test. But what I'm telling you is this is the hard test. This is the difficult one. Once you get through this, you're getting closer. So let's see, I got a little bit more to say, but before we go to break, let me come back and address some questions if they're relevant. Okay, so if you fail one section, do you only have to, we answered that. So how many times, how can you retake? We answered that. I've heard the computer stops once you get so many right. Don't know about that. That's new to me. But if you pass, you pass, I guess is what they're saying. So I don't know about that. Is it okay one-time application fee? Yes. Yes, your one-time, no, your application fee is each time you go. So every time you go, you pay an application fee and then 60 for both sections, 30 for one. How do we differentiate the national and the state part? Well, our notes, if it's a state section, I have the great state flag on our PowerPoints, also in your book. Open up any random page to your book. I just flipped and it said page 395, for example, 395, random. You see in the left-hand margin, it says in North Carolina, 395 in North Carolina. That is also alerting you to a state-specific section. So you can use your book to help you differentiate. And I got more information for you as well. Ooh, somebody's getting married on June 1st. Congratulations. So either you submit your application before you change your driver's license, or you submit your application after you change your driver's license. Do they give you a chance to review what you got wrong? No, but, and we're going to talk more about that. They do give you a report with a breakdown. And it says, this is the percentage you got right with agency. This is the percentage you got right with contracts. This is the percentage you got right with financing. You're never going to see those test questions again. So pass or fail, they won't let you review the exam. But what they do is give you a report with the breakdown. Okay, I'll get back to that. Okay. I have a little bit more to say, and we're going to go to the commission's website and look at where we can start our application, but we got to pause and take a break. So let's take 10 and we come back. I do have more to say. So again, you may want to hold off on your questions for just a minute and we'll have time. So let's take 10. We're back. I'm going to take attendance. Let's see. Oh, Marina, I got you. Just got you in. And I have taken attendance, so let me know you're back. Okay. Let me get this flashing thing out of your eye here. Could you get experience before doing posts? Basically, is what that asks. So yeah, there's no wrong way to do it. Some of you are ready to go. So as soon as you get licensed, you got a firm you're going to affiliate with, you're going to join, you're going to get started. You're on active status. You got 180 months to do your 18 months on 180 months, 18 months to do your 90 hours. Others of you may want to knock out post before you get started. And that's okay too. There's no wrong way to do that, just so long as you do the post licensing within 18 months. With the state sections, with the different sections, can you choose just to take one section at a time? No. They make you do both. If you have to do both, they make you do both. If you just have to do one, then you just do the one, but you can't break that up. It's an all or nothing. Just a little bit more here. Again, more stuff that we're getting to with license law and commission rule. And another thing we've kind of danced around that, again, we're going to spend more time on. I'm just introducing you to it because you guys can start looking at the RELINC book. It's talking about renewing our license. And the first thing, once you get your license, we got to renew them each year. And the first thing to understand is that the Real Estate Commission does not operate on a calendar year. The Real Estate Commission operates on a physical year. And the Real Estate Commission's physical year is July 1st to June 30th each year. So then that question comes in, how do you renew your license? In order to renew your license, you've got to pay a fee during the renewal period. So our license, all licenses, I should say, expire unless the renewal fee has been paid by 11:59 p.m. on June 30th. The renewal period is May 15th to June 30th. So you have 45 days. You can do it online, submit a card. When you renew your license, your status is current. A current license says only that you have paid the fee. It has nothing to do with education. Failure to renew your license by 11:59 p.m. on June 30th means at the stroke of midnight on July 1st, your license is expired. So the first thing, and this is near the end, just introducing you to it. The first question you need to ask yourself is my license current or expired? And it only comes down to paying the fee. If I could make a play on words, when you see current or hear current, why don't you take a play on words and actually hear the word currency? The difference in a current or expired license is whether or not you have shown them the money. The next step is your education. A current license can be active. A current license might be inactive. It's where you're at in your education. Are you up to date on your CE? Have you done your post licensing in time? We will talk more about CE and post licensing, but only a current license, once you've paid the fee, only a current license can be active, meaning you're up to date on your education, or inactive, meaning you're not up to date with your education, or you're a provisional broker without a BIC. You're a provisional broker that's not affiliated. So as we said, if you don't pay the renewal fee at the stroke of midnight, your license goes expired. 29 to 31 if you want to get a jump start when we talk about this in license law and commission rule, pages in the RELINC book. The other thing I just mentioned on that, again, we're going to spend some more time on, we're just mentioning it here because it's in the RELINC book. It's post-licensing versus continuing education. And no, right now, they're not the same thing. Post-licensing is for entry-level broker status. CE is for all licensees across the state of North Carolina. We all have to do 8 hours of CE a year, broken down into 2 4-hour classes. So there's a 4-hour update and a 4-hour elective. So really, you guys, let's think about this. The renewal fee for the last, as long as I can remember, has been $45. So you got 45 days to pay $45. And in addition to that, you got to take 2 CE classes. CE classes range from, 50 to 60, 65 bucks, somewhere in there. But for simplicity, let's just say they're 50 bucks each. So you got 45 renewal fee. You got $100 for 2 CE classes. $145 in 8 hours out of your year will get you licensed next July 1st, next July 1st, and next July 1st. Again, getting your license is the hard part. Once you get them, it's really not that much to keep them, as long as you're paying the fee and you're attending CE, you're doing your education. We're going to talk more when we get to license law and commission rule. What happens if you don't pay the fee? What happens if you don't do CE? What happens if you don't do post in time? All the what ifs. But again, if you can't wait, you may want to start with the RELINC book, pages 29 to 31. I think all of you should start looking at the RELINC book. By the way, I recently found out by the commission that one of the questions on your application is that you have read the RELINC book. And if you say, yeah, I've read it, and you haven't, and you get caught, they could say you lied on your application. What happens if you get caught lying on your application? She's got good character. I'm sure she didn't mean to. It's okay. We'll let her slide this one time. No, don't lie on your application. So what I'm telling you guys is read the RELINC book. They want you to. They ask you that question for a reason. All this and more is going to be covered in that book. All right. Where do we go? I don't even have that up. ncrec.gov. If you don't remember the address, Google North Carolina Real Estate Commission. It'll come up, I promise. The Real Estate Commission's website is a plethora of information. There's so much good stuff in here. Who can remind me the commission's #1 purpose? Their main purpose? I see mouths move. And I bet you if I wait just one more slide on the home screen, boom, there it is. To protect the public interest in real estate brokerage transactions. Did y'all see that? It's on their homepage and everything. What's their main purpose? To protect the public. And one way they can protect the public is by educating the public. So the things we have on the website is available to everybody. It's available to the public. And the commission says that brokers can use these things on the website to help educate the public through the transaction, through the process. In other words, we don't have to recreate the wheel. If there's a resource on the commission's website, it's available for us to use with the public. Isn't that good news? We don't have to have our creative thinking abilities. It's here. Don't spend all your study time on this website, but I do think you guys can kind of start poking around. My favorite, the places where I go most are the publications tab, specifically publications. I know I sound like I just repeated myself, but you guys see that? Publications. You know those Q&A brochures you guys have in the online learning system? Those plus so many more are in the publications tab. There's some also good resources under the resources tab. So I just encourage you guys to start poking around in here, kind of playing around and see what's available. But again, don't spend all your study time in here, but just start, familiarizing yourself with it. As we scroll down, I'm still on the home page. And as we scroll down, they're going to start reminding us about CE. Their years wrapping up. We're getting ready to get into CE season. We'll talk about CE deadlines and all that. Once you guys get licensed, you're going to have a licensee login. You'll have access to kind of the back end of the website. So you can pull up your license information. If you go, gee, did I take CE this year? You can log right in and see it. You want to pay the renewal fee? You go right there. You need to change your name or your address. It's all here in the licensee login. Also on the commission's homepage is license law and rules. You know, this class and even post licensing, we're giving you fish, but at some point we need to teach you how to fish because you're not always going to be under Lane and I. And as we said, your exams are going to be whatever's current. Your real world practice is always going to be on the current license law and commission rule. So knowing where to access the license law and commission rule, knowing where to get that information, and it starts here on the home page. They always have the current available. And this is a great resource. This answers the question, what would the real estate commission say? And the answer to that is going to be embedded usually in license law and commission rule. You have some other resources as well, but knowing where to find these things in practice is helpful. The last thing I want to show you, the very bottom, well, not the very bottom, awfully close to the bottom of the home page is a big button that says apply for a license. It all starts here. There's not a reason why every single one of you can't click on this link and start seeing what they're going to look for your application process. You can like create an account and save it and come back to it, right? So you can start your application now. I do think all of you at some point, you may or may not be ready to submit your application when we're done. You may want to wait until you pass the class to order your background check, for example. What I'm telling you guys is there's no reason why all of you can't click on this link today and start seeing what it's about. You may need to start gathering information. They want, for example, addresses for the last 7 years. So if you've moved around a lot in the last 7 years, you need time to gather former addresses. Background check. You can order it through this apply here. They have a link that takes you straight to the place with the background check. If you've only lived in North Carolina for the last 7 years, your background check, I don't know how much it is, but you should get it back pretty quickly. If you've lived in other states or other countries within the last 7 years, you can expect more expensive and for it to take longer. And I can't tell you how long and how much because each state is different. Each state has a different fee to release that information. I will say your RELINC book specifically calls out New York and said New York is known for taking, for lack of better words, their sweet precious time and getting your background check back to you. So all states are different. If you have other states or other countries, you just need to expect more time and more money. And I can't answer the questions about how much. Again, though, things you guys can click on this link and start poking around and learning more about. So when you are ready to submit it, it's further along. You could do everything in your application today if you wanted to. I wouldn't suggest the background check, but you could do everything in your application today except for 2 pieces. There's 2 pieces that you'll need that you can only get from the certificate of completion. And those 2 pieces are my instructor number and the school's number. And both of those pieces will be on your certificate of completion. If those numbers leak, some of you may be going, well, I got Julie's instructor number. I don't even know it. So good for you if you do, right? But if those numbers leak, the 2-fold of it, Lane has to submit you as completing this class. So they're not going to review your application, even if you do submit it today without those numbers, which you can't. But Lane's got to submit it on her end as well. Does that make sense? So it's a 2-fold to make sure, yes, you're applying, and she says, yes, you're good to apply. So just know that you could do everything else except those 2 pieces And you'll get those when you get your certificate of completion. What questions do I have? Just on your state exam. Hear me when I say it's a process. So I encourage you guys again to be familiar with that RELINC book. Use it as a guide. It walks you through step by step. I'm not going to go through it. I do want to show you one more thing, but it does kind of walk you through step by step. What's in the exam? What are they looking for in your application? You know, it tells you that your name's got to be your full legal name, you know, da 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 da. Could I tell you about the background check link? It's a company. I don't remember the name of the company, but it's in here somewhere. But it's the only place that they will accept a background check for. I can't remember the name of it, but it's all in your application. By the way, when you guys click on this button, you've done more than I ever have, because I'm so old. When I got my license, I was still mailing a paper application. I have never ever clicked on this button. This button didn't exist when I got my license. So once you click on it, you've seen more than I have. With that being said, Lane and I are still here to help. I'll be honest, Lane is much more versed in the application process. And there's a really good chance if you reach out to me, I'm going to say, let's call Lane. So you may want to save yourself a step. But the point is, never hesitate to reach out to either one of us if you're stuck, if there's anything we can do to help. You guys leave, you get your certificate of completion, you leave the hands of Carolina School of Real Estate and you go into the hands of the North Carolina Real Estate Commission. But we're not too far away. So if we can help, like I said, Lane's, I'm not trying to put it off on her, but Lane's better at troubleshooting. She's been through that more than I have. So there's a really good chance I'm going to say, call Lane. Make a note, page 17 of the RELINC book. I think we've seen this, but it's worth bringing up again. Specifically, the question I get is, what can we expect to see on our state exam? Well, ta-da, here's your national section, your state sections below that. It gives you the topics as they relate to the syllabus. It also tells you how many questions you can expect to see in each section. So just for example, in the national, I see contracts and agency has 16 questions, which is units 7, 8, 9, and 10. And then we got to do that again in the state section because there's state specific things for agency and contracts. So you can use this as your guide. The thing I really want to point out, the thing that's really, really, really helpful, these topics, because now the question is, well, what falls under real estate practice? Where would these 14 questions under real estate practice be? You guys see this hyperactive link up here? This takes us directly to the syllabus. And the syllabus, the sections, it loads, the sections of the syllabus are the same that they're referring to in the RELINC book. So if you want what is real estate practice, it's on page 44. So if you go and you bomb this section and you say, oh my gosh, what do I need to do? Go to page 44 and it'll tell you everything that falls under that section. And that's the helpful piece, I think, because the RELINC book corresponds to the syllabus. And this will help you know where to focus your study time, your energy. Questions on the state exam. I'll address ours in just a second. Just on the state exam. Our exam. Oh, good. Okay, so they're going to state. So yeah, the syllabus, the S in the end. This is a state section. This is a national section. So that breaks it down for you even further there. Thank you. So the state section, national, national, national. Again, what's the key is what's under each category, because when you get that report, this will help you know your areas of weakness. This will help you know where to focus. Our exam. It's coming up, y'all. Here's a good reminder of dates. Don't forget, you got a cram course on May 17th. More on that as we get closer. Right now, it's just to save the date. The last day of this class is scheduled for May 21st, and that's the day we're going to take our end of class exam. I'm going to go over the exam rules and expectations the class before. If I talk about them now, we'll forget them and we'll have to talk about them again. And I think we've learned by now, we really only have time to talk about things once. So I'm going to hold off on rules and expectations for our exam until the class before, May 16th. With that being said, I do have one thing I need you guys to start working on now. On exam day, I need all of you in a distraction-free zone. If you're in a room where other people can walk in and talk to you, that's not a good place to take my exam, end of class exam. If I see somebody in the room, I can only presume they're talking to you about the state exam. That's called cheating. The Real Estate Commission says if I suspect you of cheating, I'm to remove your exam right then and there, and then we'll deal with it. Don't make me suspect you. So the one thing you can do is be securing a distraction-free zone. I think some of you might be in the same home. That's fine. I need you in different parts of the home. I need you in different rooms. So more on our exam. And don't forget too, the retake is May 23rd. Again, more on that. To be eligible for the retake, you have to make at least a 55% on my exam, the first exam on the 21st. So if you don't make a 75%, but you at least make a 50%, you're eligible for a free second chance. How many times in life can you say that? So we'll offer a retake 50% or more. More on this. Again, we're getting there. It's amazing how fast this time goes, isn't it? I mean, for me, I crank out about 4 of these a year, and it's just amazing to me how fast these classes go. If I can answer any questions, if I can help, never hesitate to let me know. But this is where we are. We're in really good shape. We're doing really well, and we're just getting our way closer and closer. Distraction-free zone. If you have questions about what that means, I need you to reach out to me like now. Don't wait until May 20th. Fair enough? I've had students take this exam in the library before because they don't have a quiet place at home. Do some recon, go to the library and check it out. Talk to the librarian. Maybe they have a little room they can put you in. This is why I need you guys to secure this distraction-free area now so we can be ready for the 21st. Fair enough? What questions do I have? Okay, so if you fail my exam, if you don't make a 50% on the 21st, or you don't pass the retake, then you have to retake the class. The good news is Lane will let you retake it at a discounted rate. If you have to retake the class, it's okay. It is okay. There's no indication of what type of agent you're going to be. We just got to get you through these tests. So if you have to retake the class, I suggest getting in a class as soon as you can while what you have is still fresh. If you wait 6 months or a year, what's going to happen to what you have? It just disappears. It just goes somewhere. So if you have to retake, But yes, you got to keep going in the class until you get that certificate of completion. And the only way you're going to get the certificate of completion is to pass the class, the requirements of the class. Will these questions be different from the book? Of course. The questions you see on your exams, you'll never see again. So that's why we give you lots of practice, different ways. I mean, really, there's only so many ways we can ask you about agency, but they're gonna, different question, change it up a little bit. So yes, they will be different. You won't see what's on the test. Is our exam online? Yes. We'll log into Zoom like we always do. Again, I will talk about that. Good question about one thing for your exam. I'm going to ask you guys to turn off your virtual backgrounds. I know several of you have those backgrounds on, and I'm okay with that. The blurry backgrounds, I'm okay with that for class as long as I can see you. For your exam, though, not only do I need to see you, but I need to see that there's nobody behind you. So we're going to have to turn off virtual backgrounds. Does that make sense? So again, that might be part of your distraction-free zone is cleaning up your space. But yeah, no virtual backgrounds for the exam. Can I use a piece of paper and a calculator for the exam? Of course. Of course. Has everybody been calculator shopping? If you haven't, please go. Guys, I can't let you use anything other than a basic calculator. Does it have the ability to store formulas? I can't let you use it. Is your phone? I can't let you use it. I almost always have somebody show up on test day and say, I forgot a calculator. Can't I just use my phone? What do you think I say? No. I mean, it'd be one thing if I told you about it the day before, but didn't I tell you guys this on day one? Please go get a calculator. You get 2 pieces of scratch paper for both, mine and the state exam. And if you need more than 2, you can use it. You can have it, but we're going to start with 2. So of course, we're going to give you these tools. Some of you maybe you're blowing through the book, you're looking ahead, you're blowing through the book, and then you're going through the online learning system. Some of you are really utilizing the tools that we've already given you. I mean, you've already paid for the book and the online learning system through the class registration. So use the tools you have. Some of you may be looking for additional study material. Please don't go to Google. Do y'all know how much crap is on Google? Please don't go to Google looking for pre-licensing study material. I can't validate the internet. What I can do is make some suggestions on things you may want to look into if you're looking for additional study material. If you haven't done what we've already given you, do it. But if you're looking for additional study material, the author of your textbook is called Dearborn. Dearborn has an app, and it has additional test questions. It kind of has the where you answer a question that gives the explanation as to why. I can't tell you the cost. I can't tell you anything, but you may want to consider looking into, after class, please, looking into the Dearborn app. Another resource I have for you guys, when you got your book from Lane, there should have been a flyer in there for Exam Smart. And I know it's backwards, but you should have a flyer for Exam Smart. If you don't, write it down. Exam Smart. That's what they're called. And they're a prep management company. So you can see, and there's a cost and all that's on their website. But again, they offer additional quizzes, study material, supplemental material, that kind of thing. So if you are going through the process, then you may be looking for additional. But again, you guys, if you haven't utilized what we've already provided you, let me help save your wallet. Do what you have first. If you're looking for additional, Dearborn, be a resource for you to look at. Exam Smart, be a resource for you to look at. Questions? Comments? Concerns? So let's go back to the certificate of completion that you're wanting to get from Lane on May 21st. In order to get the certificate of completion from Lane, you got to do three things. You have to meet the attendance requirement. Who can remind me what that is? What's the max you can miss? I got math going on. Yeah. 15 hours. 15 hours is the max you can miss. The second piece of it is you got to make a 75% or better on the end of class exam. And the third piece of it is you have to take the midterm. So that leads me into our midterm. The link to the midterm is now available. It's now live, and it will be live. Don't go now. I know you guys are going to want to start the midterm right now. Let me tell you right now how I feel about getting your midterm results during class time. You just stamp distracted all over your face. Okay, so don't take the midterm during class. That link is live now. It'll be live until 11:55 p.m. on Monday. What is Monday's date? Monday is the 29th. So you have from after class today until 11:55 p.m. on the 29th. Where do we find the link? In the 50% material, there's a class marker midterm link, Julie only. This is your link to the midterm. So there's the 50% material. Make sure you click on the Julie link. Failure to complete the midterm exam will result in you not being eligible to take the final exam. Stop. Let me ask you guys questions. There is no extensions. There is no, more than a week. 11:55 p.m. on Monday is your deadline. What happens if you don't finish it by 11:55 p.m. on Monday? It's right there. What's it say? You are not eligible for the end of class exam. I need everybody hands up saying, yes, Julie, I hear what you're saying. That's not everybody. I need everybody's hands up saying, yes, Julie, I know what you're saying. I'm going to make you guys take an oath on this or something. I say this because I get phone calls on Monday. What do I do? Well, you got till 11:55. Go in and give it a shot. Midterm dates and times will be provided by your instructor. I've done that. Your score does not matter. I'm not looking for pass or fail on the midterm. I'm looking to see that you tried. I'm looking to see that you attempted. I suggest you treat this midterm like a real test. Take this midterm. I would set aside 2 hours in a distraction-free zone and take it like the test. Ask yourself, if I were sitting down for Julie's exam today, how would I do? It's a one-shot deal. You can't go back and take it again. You're not going to see these test questions again. We're not going to review them because, again, we're treating this like a real test. And you're not going to see these test questions on your actual exam. However, what you will get once you finish the midterm is a report with your breakdown. It'll tell you the percentage you got right in Unit 7, the percentage you got right in Unit 6, the percentage you got right in the different units. You're not going to see the questions again. They won't matter because you'll never see them again. But what we want you to know is your areas of weakness per unit. So when you finish the midterm, you and I both will get an email and it'll have that breakdown. And then I'll know that you attempted it. And that's what I need to give you credit for it. So no, we can't review it beforehand because we're treating this like a real test. Can you pause it? Nope. Clock keeps it ticking. Be ready. Treat it like the real test. Let's pretend that it's 9 a.m. on the 21st. That's what I suggest. Guys, the midterm isn't for me. It's for you. It's a check-in. Where are you right here, right now? I think some of you will take it and you may do better than what you realized. What I say to you is keep doing what you're doing. Please don't say, oh, I did good on the midterm. I don't need to study anymore. You're setting yourself up for a score of about 50%, give or take. Some of you may take the midterm and bomb and say, oh my gosh, you got time. You got time. Go back to YouTube, dedicate more time. This is your check-in point. And that's the whole point. That's the whole point of the midterm, is to give you guys those areas of weakness and to give you that check-in. Questions? Does everybody hear me? I'll remind you again on Thursday. And then after Thursday, by the time we see each other again next Tuesday, it's done. So if you don't take it, you might as well not come to class on Tuesday. Attempt it. I'm not going to call you Monday and remind you. What do we have? What do we got? Can I bookmark questions and go back? Yes. As a matter of fact, thank you. I meant to say that. That email you guys got from Lane that we use every class to log in. Hang on, pull it up real quick. We all come to this email to access the Zoom link. But also within this email is a little tutorial. The program you take the midterm on is called Class Marker. And the tutorial kind of walk you through, like you can bookmark questions, you can go back and answer. You can say skip all or see all questions and it'll tell you that they're answered or unanswered, that kind of thing. So if you haven't seen the tutorial or if it's been a while, you may want to do the tutorial again to refresh yourself. Our end of class exam is also via Class Marker. So another agenda of the midterm is to expose you to Class Marker. So it'll get you in practice of navigating the system. So that'd be one less thing you have to worry about on test day. So you may want to, and it's not long. I don't know how long it is, 8 minutes. I don't know, but you may want to take just a minute and we'll talk about bookmarking a question. You can go back and forth, the countdown clock, all that good stuff. And it's that same platform as your end of class exam. Thank you for reminding me of that. What else? Y'all want a Kahoot? Yay. Grab your phones. Let's Kahoot. Let's officially wrap up 9 and 10. Officially. Then after we Kahoot, we'll take a break. So this Kahoot is for units 9 and 10. Here is your QR code. Easiest way to get to it. If you're on the app or the website, you need a game pin. not want to play on your phone? That's fine. I just ask that you play in your mind. No, Kahoot questions are not test questions. Wouldn't that be nice? Everybody that wants to play on your phone? The competitive, does Kahoot bring the competitiveness out in you? Sometimes it does. I think that's a trait. If they were to line up a bunch of real estate agents and ask a bunch of questions, I think that's one thing they find out. We're competitive in nature. The Kahoot's channeling your inner competitiveness. Yeah, no, Kahoot music is the worst. Kahoot is the worst. I used to mute it, but then I forgot to unmute it and I couldn't hear you guys and I couldn't figure out why. So now I just don't mess with it. We gotta listen. Awful. Not my style, I guess I should say. All right, are we ready? Let's Kahoot. This is our contract Kahoot from units 9 and 10. Question number 1. A void contract is one that is seconds. A void contract is one that is, good job guys, not legally enforceable. Remember contracts, there's only 2 types of contracts out there. They're either valid or void. The difference is whether or not we have those essential elements, whether or not we have those required ingredients. 2 types of contracts. Valid contract will stand up in a court of law. The valid contract may become voidable. The valid contract may become unenforceable. The void contract, in a sense, we never had a contract to begin with because one of those essential elements is missing and it will not stand up in a court of law. Questions on this one? All right, let's see what we got. Dustin got it out the gate first, followed by Alini, Cam, S, and Victoria. Question number 2. The essential elements of any type of contract include all the following except. Eight seconds. Ooh. Let's go to our book. And specifically, let's go to page 259. So these essential elements, these are, remember, Unit 9 is like basic contract law. So maybe we're talking about real estate, maybe we're not. Basically, in real estate, in basic contract law. If the judge is ever handed a contract and is asked, is this valid? The first thing the judge is going to look at is to make sure the essential elements are included. So do we have legally competent parties, mutual assent, legality of object, and the number 1 problem topic when it comes to the essential elements of contract formation, we've got to have some form of consideration. There are no free promises. And a legally binding contract is in exchange, consideration in exchange for an act or a promise. So with this one, agency disclosure is not an essential element of a contract. Remember, agency disclosure isn't even a contract. It is just a disclosure. So what we were looking for here was the one that wasn't the essential element, which would be the agency disclosure. Questions on this one? 259. See what we got. Rafa is on the board, climbed up. Dustin's still on. Alini, Cam, and S. Amari is our highest climber, up 6 places this round. Question number 3. The law requiring real estate contracts to be in writing, to be enforceable, is... Ten seconds. What's Connor tell me? Actually need somebody to say it. Type it in the chat. Something. What's Connor say? What's Connor require?
Recorded.
Connor says there are certain documents that have to be recorded to be enforceable. Statute of Frauds says there are certain documents that have to be signed and in writing to be enforceable. Another thing we mentioned is a problem topic. So write it down. Look it up after class. Connor Act versus Statute of Frauds. I recommend a side-by-side comparison so you can see those differences. Questions on this one? Let's see what we got. Should be really interesting here. Anna's on top, Rafa, Sam's on the board, Stephanie's on the board, Dustin's still on. Question number 4. If the seller makes a counteroffer, the prospective buyer is... Ten seconds. Seller makes a counteroffer. The prospective buyer is... The seller makes a counteroffer. The seller becomes the offeror, or the buyer becomes the offeree. What are the buyer's 3 choices? They can accept it, reject it, or counter it. Nobody is bound until we have acceptance. So the seller has countered it. They've thrown the ball back in the buyer's court, if you will. The buyer's not bound to anything because the buyer now has 3 choices. They can accept the seller's counter, reject the seller's counter, or counter the seller's counter. Questions on this one? Let's see. Anna's staying on top. Stephanie's up. Dustin's back up. S is still on. Alini's back on. Daisha. Thank you. Where's she at? Thank you. Daisha's our highest climber, up 8 places this round. I'm so sorry. Thank you. Question number 5. To rescind a contract. What do you do when you rescind? Seconds. If you're rescinding it, you're canceling it. How many days do we have to rescind a contract with a timeshare? You have 5 days to cancel it. How many days do you have to rescind a contract with a new construction condominium? You have 7 days to rescind it. If you're rescinding it, you're taking it back. It's like it never existed. If you put down deposits, you'll get your money back. What are we doing if we're changing a contract? What does it mean to change it? Somebody give me a word. A change.
Amend.
You're going to amend it. An amendment is a change. To rescind it is canceling it. Questions on this one? They don't let you go back, do they? Once you accidentally hit the wrong button, there is no change in your mind in Kahoot. That's not always a bad thing. Have you guys started second guessing yourself? How many of you have changed a right answer wrong because you've second guessed yourself? Stop it. Stop it right now. The majority of the time, your gut is right the first time. Stop it. Okay, that's my soapbox for the day. Let's see. Anna's still on top. S is up. Victoria's on the board. Lauren's on the board. Amari's on the board. Debbie's our highest climber, up 7 places this round. Number 6, to assign a contract is 2. Seconds. If you're assigning it, you're transferring all your rights and responsibilities. In an assignment, the only thing that changes is the name of one of the parties. The terms stay the same. I think a great example of an assignment, and kind of gets us into the mindset we're going after lunch. Where are my homeowners on the call? And my homeowners, when you bought your home, did you have to get a loan? Was your loan sold? That's an assignment. Your terms stayed the same, didn't it? They didn't change your interest rate, your payment date, your payment amount. The only thing that changed was the name of the lender. That's an assignment. More on that after break. Questions on this one? Just got one more if you guys can bear with me. Then we'll take a break. Anna and S are staying on. Laura's on top. Jason's on the board. Victoria's still on. 7 of you are on fire. That's fun. Question number 7. In the event of seller breach, the buyer can sue the seller and force them to sell. This is called eight seconds. Buyer can sue the breaching seller for specific performance. Consequential damages is a money damage. It's kind of the above and beyond. Specific performance, the buyer could sue the seller, and if they win, the judge could make the seller perform. What is the seller's number one obligation in the offer to purchase and contract? To hand over that clear marketable title. And if the seller breaches, the buyer could make them perform, which means they could make the seller sell. The judge could make the seller sell. Questions on this one? All right. Let's see what we got. The podium winners. 3rd place, we have Jason. Came up a little bit. 2nd place is S. You'll have to tell me who you are in a private chat because I'm curious. And our 1st place is Anna. Anna. That fourth and fifth runners up here came up on the board at the last minute, and so did Shauna. So last minute shuffle. Units 9 and 10, you guys. Contracts. Go back and review that. Ah, good. Thank you. I don't know if I told you the guys or this or not yet, but back in the day when we were in person and we cahooted, I always got my top three candy bar of your choosing. That was your prize. Today, I'm obviously not doing that, so your prize is just like knowledge, But I think all of you should go out this afternoon and get yourself a candy bar. Get yourself a treat. Go get you a candy bar this afternoon. Fair enough? Sounds good, doesn't it? And I just gave you an excuse to go get a candy bar. Okay, let's take our break. When we come back, we are jumping into our financing units. I'm going to take attendance. And we are moving on to the next. And the next is our financing units. I have taken attendance, so thank you for letting me know that you're back. Both 14 and 15 are financing. 14 is more on the principles. 15 is more of the in practice. So before we can talk about what we may experience as agents, the in practice piece of it, we kind of just need to go over some basic financing principles, which is what Unit 14 is about. As we get into the financing units, this is what I suggest. I recommend you all take your future broker hat off and put on your lender hat. The best way to get through the financing units is to not think like a broker, but to think like a lender. And this is what we're introducing you to. In the real world, we're going to have lenders. We're going to have buyers referring to their lenders. We're going to encourage buyers to talk to their lenders. Again, we need a basic understanding of the process because we are the front line of our buyers. And we need a basic understanding to help get them through this lending process. So everybody have their lender hat on, snug. We're going to be wearing this for a couple classes now. And I have taken attendance, so make sure I know you're back. So Unit 14, we got two different type of title theory states, I should say. So we're going to talk about the two different type of theory states and which one North Carolina is. We're going to talk about that deed of trust that we've kind of hinted around. The other document involved in a loan is called the promissory note. So we're going to talk about both the promissory note and the deed of trust. And with financing comes math. No way around it. So we got math in this unit. We got math in 15 as well. Probably won't get to the math today, much of it. So at least we know where we're going to pick up on Thursday. So we're going to not only talk about discount points and loan origination fees and loan to value ratio, but we're going to pick up the calculator and do some calculation as well. So starting on page 384, Unit 14, the first thing we want to do is just define some words. The mortgage and the deed of trust are the same thing. We're going to learn in just a second that different states may call it different things. So other states call it a mortgage. North Carolina is awfully fancy, and we call it a deed of trust. There's a really good chance going into this unit, we have the wrong definition of a mortgage in our brains. So I got to unwind, I got to unring that bell. A mortgage is not the payment that you make every month to the lender. A mortgage is the pledge of real estate as the security. The mortgage or the deed of trust is what gives the lender the right to sell the property in the event of the borrower's default. The lender cares about one thing, and that's their money. They care about the loan amount. They care about the money you're sending them every month. And if you stop sending them money every month, now the lender has a problem. They may go after the property. We will talk about that. But the mortgage or the deed of trust gives them that pledge of security. It gives them that right in the event of default. Do not confuse the deed of trust with the deed. The deed is the document you get proving that the property is yours. The deed of trust is the security, the pledge that the lender has on the property. The mortgagor is the giver of the mortgage. The mortgagee is the receivee of the mortgage. The giver of the mortgage is the borrower. The borrower is giving that pledge of security to the mortgagee or the lender. If I may make a play on words, mortgagor, borrower, mortgagor, borrower, borrower, play on words. Equitable title is interest in the property that allows possession. Equitable title is what allows the mortgagor, the borrower, to use the property. Lenders get a bad rep, and I don't really know why. Lenders, in many cases, have a bigger interest in your property than what you do. Let's say, for example, you're buying a home at $100,000 and you're putting down 10%. So how much are you putting down? $10,000, which means you're asking the lender for the rest. What is the rest? Who has the bigger interest in this property? I mean, your $10,000 is cute and all, but whose money is being used to buy this property? It's the lenders. And they've got to do what they can do to protect their interest, to protect their, in this case, $90,000. So they have, in many cases, they have an interest, a recordable interest in the property referred to as the deed of trust. But they're going to let the mortgagor use the property. They're going to let the mortgagor live in the property, maybe profit from the property. But there are certain things that the mortgagor needs to do to protect the mortgagee's interest. And we will talk about that. Default, when you stop making your payments. How many months can you default before you go into foreclosure? The answer is that depends. That's your agreement between you and the lender. You know how we've said all real estate agents and firms are different? Guess what? All mortgage lenders are different as well. So they all have different policies, different terms. Maybe they allow you to miss 4 months before they start the foreclosure process, or maybe it's just 2 months. But if you default, you've missed a payment, the borrower failed to make a payment. And then hypothecation is the act of pledging the property as security. You got to put that property up for collateral. Again, it's what protects the lender's interest. The lender will keep an interest in this property until you pay them back that $90,000. So just defining some words. Couple different types of states. Other states, I don't know specifically which ones, but other states are a lien theory state. And a lien theory state is a two-party instrument. So the parties involved in a lien theory state are the mortgagor, the borrower, and the mortgagee, who's the lender. The document used in a lien theory state is called the mortgage. And in a lien theory state, the borrower holds both legal and equitable title. So not only do they have the legal title, but they have the equitable title, which gives them permission to live there. In the event of default, and we have to go through foreclosure, lien theory states use a judicial foreclosure process, which means other states have to go to court. They have to stand in front of a judge. You guys see the word judge kind of built into that. So judicial foreclosure tells us to start the foreclosure process, we have to go to court. Judicial foreclosure process is timely, is costly. Other states then, including North Carolina, is a title theory state. And in North Carolina, we have a three-party instrument. We have three different parties. The grantor is the mortgagor, borrower. The beneficiary is the one that is going to benefit from the property in the event of default. So the beneficiary is the mortgagee or the lender. And then the trustee is the third party handling the affairs on behalf of the beneficiary. The trustee is an attorney, and they are handling everything on behalf of the lender. So in the event of default, the foreclosure is imminent, then the trustee is going to kick in and do their thing to get the property for the beneficiary for the lender. The document we use is the deed of trust. More on that. Title theory states the borrower has that equitable title, which means they have the right to live there. They can profit from the property as long as they're not violating the agreement between them and the lender. But the trustee holds the legal title on behalf of the beneficiary until either default or it's paid in full. We do not do a judicial process in North Carolina. Our foreclosure process is called power of sale, which means in the event of the default, the trustee has the power to sell the property on behalf of the beneficiary. So there's two documents used with the mortgagor and the mortgagee. There's the financing instrument, which is the promissory note. More on that in a minute. The promissory note is the IOU. It's the contractual agreement between lender and buyer, lender and borrower. I owe you X amount in the terms of the following: interest rate, monthly payment for however many months. The promissory note is not recorded. It's just the contract. The other document then is the mortgage, or if we're in North Carolina, the deed of trust. That's our security instrument. That is what gets recorded. The whole reason of recording the deed of trust is to record the lender's interest. Remember our lien priority? This lender wants to be first in line, the main lender that you bought the home with. We'll talk about other lenders in this unit as well. But their collateral, what they have to prove that they are owed this money, is the deed of trust. The deed of trust is what gets recorded. Some essential elements of the deed of trust. I wish they would put this in bullet form for you in your book, but it's one run-on paragraph, page 386. What do we know about those essential elements? What is this telling us? We talked about essential elements of a deed, essential elements of a contract. Yeah, the essential elements tells us what's necessary. What is the judge looking for when they're trying to determine the validity of a document? What is the judge looking for? I always think of essential elements like required ingredients. Yep. So the required ingredients of a valid deed of trust. The deed of trust has to refer to the promissory note. It's got to clearly state what it is. All it is security. As long as you're making your payment, as long as the borrower is making their payment each month, we're good. The problem is when the borrower stops making a payment and another one, etc. So we need to clearly state that that's the point of this document, is to offer that security in the event of default. We need the name of the lender and the borrower in the deed of trust. There's our accurate legal description. Statute of fraud says it has to be in writing and signed by all parties. Connor says it has to be recorded. And then it's got to be delivered to and accepted by the lender or the trustee, so they can manage it on behalf of the beneficiary or the lender. So with the deed of trust, with the mortgage, there's some obligations, some promises on both sides The obligations of the borrower or the mortgagor, their number one responsibility is to make those payments. You agree when you take this 30-year loan or 15 or 10, whatever it is, that you're going to pay X amount every month for the next however many months. So your number one obligation as a borrower is to make those payments. The buyer or borrower is responsible for paying property taxes and maintaining homeowners insurance. With that being said, my homeowners on the call may tell you that part of that payment you send in every month includes a 12th of your taxes and a 12th of your insurance. We will talk more about that. The lender oftentimes will collect some of the annual property taxes and some of the homeowner's insurance, keep it in an escrow account on the borrower's behalf. So when these bills become due, the lender can make the payment on behalf of the borrower. Understand, it's still the borrower's obligation to pay him, but the lender will often collect money to make these payments on behalf of the borrower. Isn't that nice? Thank you, lender. I get a letter once a year from Randolph County that says your taxes have been paid. And I think, well, gee, that's nice. And I get an email from Allstate once a year that says your homeowner's insurance has been renewed. And I think, well, golly, that's awfully swell of the lender to do that for me. Guess what? They don't do it for me. They do it to protect their interest. Let's say you decide, let's say this wasn't a thing and they're not collecting from you and they leave it totally up to you to pay taxes and insurance. And you decide you didn't really feel like paying taxes last year. Maybe you don't really feel like paying taxes this year. Maybe you don't feel like paying them next year. At some point, isn't the county going to come after you? At some point, may the county not come after the property? They may foreclose on you. Remember, property taxes are a superior lien, which means they get paid first. So if the county has to foreclose on you because you're not paying your taxes, the county forecloses, they sell your property for them to get their money back. Do they care about what you owe the lender? Do they care about what you owe all those lien holders? All they care about is getting their money back. So how can the lender protect their interest knowing that they are not number one in that line? They want to be as close to number one as they can, but they always have the superior liens ahead of them. So the lender says, just in case you forget, I will pay taxes on your behalf this year. That's what they can do to protect their interest. Homeowners insurance. If you're getting a loan, the lender will require homeowners insurance. If you're a cash buyer or you have it paid off, homeowners insurance is highly recommended. It's only required when a lender's involved. Why? To protect their interest. If the house burns down and you don't have homeowners insurance, what's stopping you from driving off into the sunset and never looking back and leaving all that debt with the lender? So how can they protect their interest? They're going to pay these bills on your behalf. Isn't that nice? They're not doing it for us, you guys. They're doing it for themselves to protect their interest. More on that. Another obligation of the borrower is to maintain the property. We can't have waste. They can't destroy it. And then a lot of promissory notes require lender authorization before demolition, major alterations, etc. Again, to protect their interest. When the loan is paid in full and the lender no longer has an interest, that's when the borrower gets legal title. In other words, the lender will do what's called a deed of release. And that deed of release releases you from the deed of trust. It releases you from that interest with the lender. By the way, when you pay that mortgage off next year, your letter from the county is going to say you owe taxes in the amount of. When you pay that lender off, that email from Allstate's going to say you owe for homeowners insurance. Once you pay that loan off, they're no longer collecting that to pay those bills on your behalf. Questions so far? So if these are the obligations of the borrower, what rights do they have? Well, they have the right to possess and use the property without interference from the lender. Even though the lender has an interest in the property, we shouldn't have to worry about them showing up on our doorstep. Other rights to the borrower, the right of defeasance says that the deed of trust will be null and void once that last payment is made. Again, the lender's interest totally goes away once we pay him off. What's the lender care about? Their money. The loan amount, their money. The right of redemption, we're going to talk about redemption in just a second. If you're redeeming yourself, you're saving yourself. And one thing that the borrower has the right to do is to save themselves from foreclosure. How do they do that? Pay the whole note off. If you're in default, the right of redemption says you can avoid foreclosure if you just pay it off. More on redemption in just a second. This is a two-way street. So if we have rights of the borrower, then we also have rights of the lender. Their number one right is to collect the loan. They also have the right to assign the debt. Remember we were talking about assignment in our Kahoot game? We said with an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. Most lenders, once the loan is originated, most lenders will sell the loan. In the biz, it's referred to as servicing the loan. The lender may service the loan in-house, or they may service it and allow another lender to take it on. Some lenders still service theirs in-house. Most will sell them to another lender. We're actually going to talk about why they do that, why they may assign the debt when we get to 15. So bear with me. The lender also has the right to proceed with foreclosure in the event of the borrower's default. Again, is it a 2-month default? Is it a 6-month default? The answer to that question lies in the promissory note. That's the contract between the borrower and the lender. And it should tell you this is how many months you can miss and avoid foreclosure. So rights of both parties. Foreclosure methods, we've already mentioned. The judicial foreclosure is the court process in a lien theory state. The document used is a sheriff's deed, and I always remember it this way. If the judge takes the property, the judge themselves is not going to the property to take it. Who are they sending? They're going to send the sheriff. So in a judicial foreclosure, the property can be acquired via a sheriff's deed. Non-judicial foreclosure, then the power of sale, North Carolina. We said we had 3 parties. And in North Carolina, we use that trustee to manage the deed. So if we lose the property in North Carolina, the power of sale foreclosure, we will use a trustee's deed. Other states, we don't do a strict foreclosure in North Carolina often, but other states might do a strict foreclosure. This just says that the court establishes a period of time and says the balance due is on this date. And if you can come up with it, great. If not, you're out. We don't do this in North Carolina. Again, what we have is the power of sale foreclosure. With that being said, the power of sale foreclosure does require a brief appearance in front of a judge just to get this ball started, to get this process started. But it's not as timely and costly as the judicial. Like the whole process is handled in front of a judge in a judicial foreclosure. And the power of sale, you already have that permission, you already have that power. We just need a judge to say, "I go ahead." So remember back in Unit 3, we talked about that lien priority and how everybody's standing in line with their hand out waiting to be paid when you sell the property. And the basics of the lien priority says all liens are paid in the order in which they're recorded, except for the mechanic's lien that's paid in the order in which the work began. Sound familiar? So we had our superior liens that are always paid first. And then you have all liens paid in the order in which they're recorded, except for the mechanic's lien that's paid in the order in which the work began. With a foreclosure, lien priority can look a little bit different. So in a foreclosure, the first thing to get paid is the cost of the sale. What's the cost for the trustee? What's any court cost? That little appearance we have to make in front of the judge, that costs money. So the cost of sale will get paid first. Then our superior liens, real property taxes and government special assessments are our superior liens. Then you pay that deed of trust that started this whole thing. And then all other liens are paid in the order in which they're recorded, except for the mechanic's liens that's paid in the order in which the work began. Lastly, if, and I strongly emphasize the word if there's anything left at the end of the line, the surplus will go to the borrower. Here's the deal. Creditors can't make more than what they're owed. So all they can collect is the outstanding balance. And once one person in the line is paid, then we pay the next and the next and the next and the next until we pay it off or don't. At the end of the line, if there is any left, the surplus will go to the borrower. And again, I stress the word if, because quite frankly, if there was a surplus, there's a really good chance we wouldn't have to go through foreclosure. Foreclosure can be tough on a person, not just the emotional piece of it, the mental piece on it, but of your financing as well. A foreclosure is going to follow your credit report around for 7 years. So you may have 7 years that you may not be able to get a loan because you had that foreclosure on your record. Sometimes foreclosure, I had a student a couple classes ago that stayed on after class and talked to me. And she said they inherited property. Somebody in their family passed away. Her and her siblings inherited property that they couldn't afford to pay. They didn't want it. They didn't ask for it. They got stuck with it. And they ended up losing it in foreclosure. But because they were the ones on the deed, who was the one? They were the estate, you know? So foreclosure isn't always, I know we tend to paint the picture of you should pay your bills, but what if you get a property dropped on you all of a sudden? Can you pick up that monthly payment? So it's not a good situation. It's tough. It's tough. If we're ever asked to list a property that's going into foreclosure, you'll probably be dealing with the trustee directly. They may have already acquired it or in the process of acquiring it. Again, you guys, and I'm not trying to make the lender sound cold and heartless here because they are people, but we have to remind ourselves what their number one priority is. What's the one thing that they care about? And what they care about is that $90,000 that they gave you to buy that $100,000 home. Does that make sense? And if you can't do your end of they did their end of the promise. They gave you the $90,000. Now it's the borrower's end of the promise to pay that back. And that's where the lender has to have something in place to protect themselves. If at the end of the foreclosure, you have lien holders, number 4 there, you have lien holders at the end. Once the money's out, the money's out. So keep in mind, this lien priority, it's not giving you the right to collect. It's giving you the right to stand in line and hope that there's enough to collect. But if the money runs out and the guy before you, nothing left. There is no guarantee. But the best thing we can do with lien priority is give you a place in line. Similar, but not quite the same to foreclosures as short sales. And we will talk a little bit about short sales and these financing units. We mentioned a redemption or a period, an opportunity to save yourself. Again, if you're redeeming yourself, you're saving yourself. And in this case, you're just saving yourself from foreclosure. We got a nice picture on page 388. Depending on what state you're in, depending on our redemption period. The equity of redemption means that the borrower has the opportunity to redeem themselves before the foreclosure sale. North Carolina, we're a statutory redemption period, which means the borrower can save themselves after the sale. So the foreclosure sale goes down. The buyer has or the borrower has a 10-day period to come up with that amount. And if they can't come up with it within 10 days after the sale, they're done. If another bidder comes in and makes another bid, that 10-day count starts again. That borrower will always have 10 days after the sale to redeem themselves. If they can't do it, by the way, I got ambulances and sirens going up and down the street. Can you guys hear them? No? Okay. I'm just trying not to talk over them if I pause. So you have this 10-day period to come up with the whole note due. That's how you save yourself from foreclosure. You pay off that deed of trust. You pay off that balance. Back to our lien priority, all those people standing in line with their hands out. What about the ones that didn't get paid? What about the ones that the money ran out before it got to them? Those guys may have the right to file what's called a deficiency judgment. A judgment is a general lien, not a specific lien, but a general lien. Who can remind me what a general lien attaches to? What is a general lien attached to? Yeah. The general lien, the judgment attaches to the person. So this will follow you everywhere you go. Any loan you ever apply for, home loan, car loan, student loans, any loan you apply for, this judgment, this general lien will pop up. The specific lien attaches to the property. Unit 3. So the deficiency judgment is a general lien. This is what the creditors, this is an option they have. Again, when that money runs out and they're still standing in line going, oh man, there wasn't enough for me, they may consider filing a deficiency judgment. Still try to get paid at some point. In North Carolina, seller financing, the seller can't sign a deficiency. The seller can't issue deficiency judgment because they're already in line as a lien holder, and they're probably up front with that deed of trust. They are the deed of trust. And then we talked a little bit about short sales. So we mentioned this the other day when we looked at our addenda in unit 10. A short sale. In order to qualify for a short sale, we must have these three pieces. The three pieces required is what you're looking at right here. With a short sale, the borrower is underwater. By the way, with a short sale, the borrower is the seller. They are the ones that are unable to make the payments anymore. Short sales are a little bit easier on the individual than a foreclosure. Short sales, for example, only stay with you for 3 years, as opposed to the foreclosure that sticks around for 7. So the first thing we have to have in a short sale is that the seller is underwater. And what we mean by that is I can't sell your home for all the debt you have. You owe more than what the property is worth. That's what it means to be underwater. Piece number 1, seller's underwater. The second piece of a short sale is that the seller doesn't have liquid assets to make up the difference. A liquid asset is readily available funds. So what do you have in stocks? What do you have in bonds? What do you have in your savings account? You don't have enough to make up the difference, make up that insufficient purchase price. The third piece of it is that the lien holder has to agree to, the lien holders have to agree to release their liens, accepting an amount less than what they're owed. What we're doing with the short sale is asking the lien holders to not accept as much as what they're owed. In order for a short sale to happen, all of the lien holders have to agree to release those liens. All of them have to agree that I will let you go with accepting less than what you owe me. The lien holders may do a deficiency judgment at the end after closing to protect the difference, the balance that you're owed them. Here's the deal, you guys. When a property is listed as a short sale, it is a short sale potential. A short sale potential is a material fact that we have to disclose. Remember what we've been saying. Buyers have the right to know what they're buying. So if they're getting into a short sale, we've got to disclose it's a short sale potential. I don't have short sale approval yet. We just have a short sale potential. So you come in and list a property like you always do. We go on the market, a buyer makes an offer, buyer and seller negotiate the offer like they always do. This piece of it hasn't changed. Where things start getting different is once we have a contract. Now that we have a signed contract, a bona fide contract and buyer, that's when the lien holders start their process to determine if they're going to approve the short sale or not. But the lien holders aren't going to touch it until they know that a ready, willing, and able buyer is willing to purchase the property for this amount. We could have an appraisal done that gives us what the appraiser thinks. We could say, do CMAs to determine probable sales price. But until we have a legitimate contract in our hand, lenders will not consider the short sale. That's why we call it a short sale potential. Once we're under contract and they review the process, that's when we wait for short sale approval. And in order for this property to continue as a short sale, we have to have all of the lien holders' approval. We have to have all the lien holders agree. Don't let the name fool you. Short sale has nothing to do with the amount of time that these things take. Short sale is referring to the fact that the seller is short on assets. The seller is short on funds. They say on average, you can expect on average 6 months from contract to closing with a short sale. It takes the lien holders time. And while they are approving this short sale, while they are deciding if this is something they'd be willing to do, the name of the game is patience. All we can do is sit and wait to find out if we're going to get lien holder approval or not. The short sale addendum that we might look at briefly on Thursday, because it's a good form. The short sale addendum creates a contingency. And what this contingency says is, I can't sell you my home if I don't get the lien holder's approval. All of the lien holders. So if one of them says no, we can't sell this via short sale. But none of them are going to look at it until we have a contract. If they say no to the short sale, then you're heading to foreclosure. And bottom line for the lien holders, it comes down to time versus money. So they're going to approve the short sale of foreclosure. They got to look at their own records, at their own books to determine which one is best for them. So it creates a contingency. So in other words, if we don't get short sale approval, then the seller's no longer on the hook. The seller's no longer legally obligated to sell the home. When it comes to short sales, lender hat off for now. Put your broker hat back on. That's hard to say. A potential short sale is a material fact. We've got to disclose this is a short sale potential. If you're ever called to list a property that's a short sale potential, we got to get everybody involved. We're calling everybody. We're having the seller CYA and CYA. Call your attorney and call your accountant. We got all sorts of people involved. So the seller's dealing with usually the main lender, the primary lender, but all other lien holders have to be on board as well, which may require some work of the primary lender to make this happen. And then the seller needs to know the tax or the financial consequences of a short sale. Again, how does that affect their credit? What can they do? So we got to call in their attorney and their accountant. And then we're going to use the short sale addendum to make sure we're handling it. We're going to read that form, make sure that we're handling it. I've done 2 of these in my career. I was the buyer's agent on both sides, on both times, I should say. The first short sale I did, it was just a little condo. We got through it. Contract to closing was about 4 months. So I was under the average. The next short sale I did made up for it. Contract to closing was 11.5 months. The name of the game is patience. Once we went under contract, there was nothing that anybody could do until I got, y'all remember those, those moments in times where you always remember exactly where you were and what you were doing? When I got that phone call telling me this 11.5 month short sale, I can tell you exactly where I was and that's that moment in time. And the listing agent called me and said, we have approval. I never thought I was going to get that phone call. Long time, you guys. That's what these things are saying. They're not short in time by any means, and prepare your buyers and sellers for this. Do buyers have to make an offer on a property that's a short sale potential? No, but it's something that they want. Maybe it's an investor. In my case, my buyers wanted the property. It checked off all the boxes. They had made arrangements for somewhere else to live, and they said, we can sit back and wait however long it takes. Careful what you say sometimes, right? But just prepare. And I don't know. It's not like I can call the lien holder every day and say, do we have approval? Do we have approval? Do we have approval? All we can do is just sit and be patient. I'm going to end it here today. I'll try to start Thursday. I'll make a note. I'll start Thursday where we can look very briefly at that short sale addendum. Also on Thursday, we're going to finish Unit 14. Not too much more before we get into the math. So be prepared to do some math first thing Thursday morning or early Thursday morning. After 14, we jump into 15. So please look ahead. Let me know if I can answer any questions. You guys have a good afternoon. We'll see you Thursday morning. Thank you.